I will open our meeting. Welcome to the February 10th, 2026 meeting of the Planning Board. First, we'll take a roll call to introduce board members and staff. All right, Mike Derderian,
Here.
Maureen Collins-White,
Here.
Tim Haladina.
Here.
I'm Ellen Rawlings. I'm also here. We are also joined by Jess Cole, our recording secretary, Nora Loughnane, our director of community and economic development, Amanda Wolf, our housing and land use planner, and Charlotte Lynch from Westwood Media Center. Okay, sorry. I saw something in the Q&A, just making sure it was not Phil.
It was in response to the bathroom break.
Gotcha. All right. This meeting is recorded by Westwood Media Center and broadcast live on local cable television Comcast Channel 6 and Verizon Channel 42. Meetings are also live on the Westwood Media Center's YouTube channel. If you're interested in joining the meeting via Zoom, you can find the login directions in the Planning Board meeting notice that is posted to the calendar section of the town's webpage at https://www.townhall.westwood.ma.us/. We will begin the meeting with only the board members and staff unmuted and on video. As the chair recognizes individuals to speak, we will unmute them. Board members may choose to mute themselves when they are not speaking in order to minimize background noise. For applications, the chair will first invite the applicant to address the board and give a presentation summarizing what is being requested. Board members received the application materials prior to the meeting and will have reviewed them. Board members may ask questions during and following the presentation. Staff and outside experts will provide comments to the board. For agenda items that are not a public hearing, the opportunity for public comment will be at the discretion of the board chair. For agenda items that are for a public hearing, the public will be given an opportunity to comment after board discussion. Public comment will only be read or heard once the chair has opened the public comment period. The chair will ask for any final public comments before closing public comment. During public comment, attendees may use the raise hand feature to speak or type a question in the Q&A at the bottom of your screen. Attendees will not be on video, but will be unmuted if called on during the public comment portion. To raise your hand, click on the raise hand icon at the bottom of the screen and wait for the host to call on and unmute you. You may then click lower hand once you've been called on. For those participating by phone, you can raise your hand by pressing *9. Once unmuted, please identify yourself by stating your name and address for the record. Please direct all comments and questions through the chair and only have one person speaking at a time. Those making public comments will have 3 minutes to speak. All people will be given the opportunity to speak. In the interest of time and fairness, repetitive or off-topic comments may be limited. Additionally, comments may be submitted by email or regular mail prior to the meeting. When we come to that part of the meeting, I will remind everyone of the process. Following the public comment portion, the board will deliberate and make a decision or continue the hearing to a specific future date. All remote meetings require that votes be taken by roll call. When a motion and second has been made, the chair will ask if there's any further discussion before proceeding to a roll call vote and will then restate the results of the vote. All right. Oh, and we've been joined by Phil Giordano. Hi, Phil.
I'm here.
And we also have Mike Perkins, our building commissioner. So we do have a full planning board and guests. And in the interest of transparency, we currently have 6 attendees who are also present at the meeting and the 10 folks who are on your screen. All right, staff, do we have any changes to our agenda this evening?
No changes.
All right, then sorry, I got to go back to my meeting minutes or my meeting screen. Then our first agenda item is warrant articles, continuation of the public hearing for consideration of proposed zoning bylaws, zoning map, and or general bylaw amendment articles for the May 2026 annual town meeting, continued from January 20th, 2026. And I will ask if we're all in agreement to kind of facilitate discussion, if we could focus on the deltas. So if there's changes to the language in an article currently, before we jump into discussion, if we can kind of highlight that. If article language hasn't really changed, if nobody objects, maybe we just kind of move right into discussion. Because we did have a full reading of the articles at our last meeting, so I think they've been read into the record. So if nobody objects, I'd love to proceed that way. If someone objects, please tell me. I'm not hearing any objections. Awesome. All right, then Nora, Amanda, take it away.
Okay, so our first article, Planning Board Article 1, has to do with the battery energy storage system regulation that the Planning Board has been discussing. The bylaw is only slightly changed since it was last discussed at your hearing on the January 20th. And the only change that's been made is the addition of a footnote number 13, to the use chart for the 6 listings of accessory use solar BESS systems. So first we have solar BESS tier 1. Then we have solar BESS tier 2, 3, or 4 pursuant to section 7.6, which is your solar design review section. Non-solar BESS tier 1 and non-solar BESS tier 2, non-solar BESS tier 3, non-solar BESS tier 4. And all of them have footnotes added saying that all solar energy systems and solar BESS facilities must comply with section 5.0 dimensional requirements and 5.2 table of dimensional requirements, including minimum setback requirements for the district in which they are installed. I think actually, as I'm looking at that now, I think that should say all solar energy systems and BESS facilities. So it's not just a solar BESS facility, but any BESS facility would have to comply with the dimensional regulations.
Thank you. Oh, and I did not state this ahead of time, but again, as if there's board consensus, I think it makes sense to proceed as we have in the past. We take each article one at a time. We discuss amongst ourselves. We open it up to public comment on each article. That way we're not just holding public comment to the end. So is that still amenable to everybody?
Yes.
Awesome. All right. Board member comments, questions, discussion on proposed Article 1, the BESS article. Oh, and just to kind of expectation set, I think it's important that we kind of finalize whatever language we really want to move forward with on all of our articles this evening, because we will be going to FinCom at the end of the month, and it's good best practice to have our language as solid as we would like it to be before we go to FinCom. So tonight's really our chance for that. So on any of these articles, I think we need to have kind of robust discussion and make sure that we come to consensus on what we would like that language to be at this point. So just wanted to set that expectation.
So just as a reminder to anyone who doesn't remember what we were talking about with the BESS systems, we're regulating solar BESS systems and non-solar BESS systems, and we're regulating them by tier type. The definitions are in this bylaw section for the different tier types and for a solar system versus a non-solar system. So these are the definitions that are added. Tier 1 is up to 250 kilowatt hours. Tier 2 is between 250 kilowatt hours and 10 megawatt hours. Tier 3 is between 10 megawatt hours and 100 megawatt hours, and Tier 4 is over 100 megawatt hours. The board cannot deny a solar BESS facility. They would have to allow solar BESS facilities, but could impose reasonable conditions on tiers 2, 3, and 4. Tier 1, BESS systems, solar or non-BESS, would simply be allowed subject to a building permit.
Thank you, Nora.
I have no
So-
comments. I think this reflects a lot of what we talked about at the last meeting, so I'm happy with it.
Thank you.
I echo Tim. I agree.
Excellent.
Yeah, and I think a lot of this is regulated. So that language all looks good to me. And then sort of like the substantive decisions that we made last time in terms of limiting the non-solar 3 and 4 in residential areas. I'm completely fine with that, and I think that all looks good.
Thank you.
And also as a reminder, this is a first step in regulating BESS. We do expect to have to come back and fine tune this as the state adopts its final guidelines.
And I agree with what they said.
Excellent.
Yeah.
I love board consensus. And so Nora, are we thinking like that time frame would likely be like next spring? We're not looking at this needing to be touched before that, or?
Yeah, well, it wouldn't have to be before next spring, but we think we probably will have the final guidelines in time to and the model bylaw will have been formalized and adopted by other communities by then, so we'll have a chance to see how it's working before we attempt to adopt it.
Excellent. All right, then I'll open it up to public comment on proposed Article 1 on battery energy storage systems. If there's any member of the public that would like to offer comment or ask a question, please raise your hand or type your comment or question in the Q&A. We just need your full name and address for the record. And we'll give that a minute. I'm not seeing anything at this time, but if something pops up later, we can always circle back. All right, if the board is okay, we can move on to proposed Article number 2.
Article number 2 proposes changes to adult daycare. Currently, it is limited to no more than 20 adult clients at a facility, and this proposed bylaw change increases that to 30. I'm looking, that probably should have the word 30 is written in there as well.
This one seems pretty straightforward. Any board member comments or questions on this one?
I think we discussed
was
this and we're
straightforward.
comfortable. I'm comfortable.
Go back
So-
and
Maybe that's the bigger question. Are folks happy with the language in its current state? We feel consensus, we feel comfortable with the language as written.
Mhm. Yes.
I do.
Yep.
Excellent. Nora, staff, did you have anything else on this you wanted to share?
no, I think it was fully discussed at the last 2 sessions.
Agreed. Then I'll open up the floor to public comment on proposed Article 2 at this time, the adult daycare proposed changes. If anyone has a comment or question about this one, please either raise your hand or enter it in the Q&A. All right. And again, if something pops up later, we can always circle back. Then if folks are comfortable, we can move on to proposed Article 3.
Planning Board Article 3 proposes changes to animal daycare. So this does it in a couple of ways. Right now, pet care facility is defined to exclude animal daycare. We changed the definition by adding unless such daycare is accessory to the primary services and a special permit has been issued by the Board of Appeals pursuant to section 4.1.5.19 and valid license permitting animal daycare is in effect. Then we go to the use chart and we change pet care facility to pet care facility with animal daycare, and then add a second use category, pet care facility. I'm sorry, the first one was pet care facility without animal daycare. The second one would be pet care facility with animal daycare. And when we have that second use with animal daycare, we make it allowable only by a ZBA special permit in the local business A, local business B, highway business, industrial, and industrial office zones.
Thank you. Any board member comments or discussion on the language for this article as proposed?
I think
And
that
we-
it looks good. Yeah, we tightened that language last time, and I think I don't think it needs anything else.
Agreed.
Agreed too.
Excellent. Yeah, we spent a great deal of time on this one, so I'm comfortable with this language as well. And I think it reflects what we've discussed thus far. All right, then I'll open it up to public comment on proposed PB3, animal daycare. If anyone would like to comment on this article, please raise your hand or enter your comment or question in the Q&A. I'm not seeing anything at this time. All right, so the next proposed article is PB4, amendments relative to definitions.
Yes, so this one recommends some various amendments to definitions, and it also recommends some new definitions be added. So the first definition that it proposes an amendment to is the definition for alteration. Currently, the definition for alteration only refers to alterations as applied to a building or structure. And the question has come up, what is an alteration when it's not applied to a building or structure? What is an alteration when it's a site alteration? So currently, the building commissioner determines what that is. And this is his suggestion to put language into the alteration definition to clearly define what is an alteration, not with regard to a building or structure. So it's that last sentence that's been added, as applied to a site, material change in materials, grading, landscaping, circulation, or other material factor determined by the building commissioner to result in an altered site. The next definition has to do with temporary structures. This is adding language that specifically includes a pod or a storage container which is not associated with an ongoing construction project operating under a valid building permit. So what that does is it expands the definition of temporary structure to take into account a pod that isn't associated with a construction project. If someone has a pod that is associated with a construction project, it's not considered a temporary structure. It's just considered ancillary to the construction project. But if you're not doing construction on your home, and for whatever reason you have decided that you need additional storage, and you want to locate a pod in your driveway or in your yard, you're able to obtain a temporary structure permit to put a pod there for up to 12 months.
Thank you.
Mhm.
And I think we've talked about the rest of the electric vehicle section. Any questions or comments from board members? I know we did get some feedback from a resident, and the pods and the alterations were part of that feedback. So I don't know if everyone had a chance to read it.
Yeah, I have a question for the staff. So for the Nora, for the definition of alterations, can you explain like the impact of that definition? So I assume that word is used, right, in other parts of the bylaw, and it could say something, when there's any material alteration or an alteration, this must occur or you must seek this approval. Can you just give like just a high level background on the impact of changing the definition?
Sure. So the defined term only applies where the term is used in the bylaw. So the term alterations comes up, for instance, in the section 7.2, environmental impact design review. And that explains that if you want to alter your property, if make alterations to a property, you need to apply for environmental impact design review with the planning board or administrative EIDR review in cases where that would be appropriate. So that where the term alteration comes into play, this change in the alteration definition makes it clear that the building commissioner will only consider it an alteration if it's a material change, not a lesser immaterial change, if that's helpful. So it's trying to
Yeah.
say that the building commissioner will determine whether it's an alteration or not, but there are some things that are de minimis and will not be considered alterations. Now, this only applies to non-residential, multifamily residential properties because that's what's governed by the planning board's review under EIDR.
Thank you. So this wouldn't, if I were doing something to my house, this would have no bearing.
It would not. So what you can and cannot do to a residential property is pretty much governed by the building code, not so much by the zoning bylaw. Single family and two-family residential structures are generally exempt from regulation under the zoning bylaw. So we have requirements for setback requirements and height requirements and number of units on a property, but not regulations with regard to how a property is designed or constructed or altered. That would not come into the zoning bylaw.
Thank you for the clarification. Maureen, I see your hand up.
Yeah. I just wanted to clarify that when I interpreted applied to a site, I thought that meant something like the Zavarian project or something bigger that was being constructed, and that is considered a site versus that's what he's speaking about when he says site.
Well, a site is the property on which a project is being undertaken. So for Zavarian, it's that large site. For something like a recent application was the Kring offices on Washington Street. The property is the site. So they weren't really they did some alterations to the exterior of the building, minor alterations, but their principal alterations were actually to the site itself. They changed the parking, they repaved the area, and the board reviewed those alterations to the site. So this just makes it clear. It doesn't change what you can review or what you can't review. It just makes it clear that the building commissioner will determine whether it's actually a site alteration or not. And if it's not a material change, it's not going to be considered an alteration.
Thank you.
Thank you. Amanda, I thought I saw your hand, but then it went away.
Yeah, Nora covered it, so it's fine.
Just wanted to check in. Thank you. Any other discussion around the alterations definition?
I just wanted to clarify, how do you like, so a site versus a residence, is that just understood in the bylaws? Is that it's not defined? Is this word site defined anywhere? Where does that like understanding come from? Is it
Well,
just historically how it's used? Yeah,
it's not an understanding of the term site. It's about what the bylaw controls and what it doesn't control. So
I
the
get it.
bylaw requires review by the planning board for alterations to non-residential, multifamily residential, and institutional properties. It does not require the review of single and two-family residential properties. And it doesn't because those are specifically exempt under the Dover Amendment.
Got it. That makes sense. Yep. Thank you, Nora.
Thank you. Any other discussion from board members around the definitions? I know the other one that we got the feedback on from the same resident was about the temporary structures. It didn't, there was some question as to whether or not the pods are a problem or that, and I just, Nora, for context, this was brought to us by some residents, right? Like this was not a staff suggestion.
No, this was a request from residents who were concerned about a particular case where there was a pod sitting in a driveway for a number of years. And since this resident asked us to take this up, we did hear from other residents that had similar concerns. So what this does, if you have a pod now, that's perfectly fine. You can continue using it if it's associated with a construction project. If it's not associated with a construction project, after a certain period of time, you'll get a call from the building commissioner asking you to apply for a temporary structure permit. And that temporary structure permit is temporary. It's only valid for a period of time. I believe it's for 6 months with a renewal for up to 6 months more, so a total of 12 months. But if you need a pod because you're undertaking construction, that's not considered a temporary structure. That's addressed under the building code.
Thank you. Oh, it looks like we have something in the Q&A. Oh, Nada, we just need the rest of your contact information. I'm sorry. Your how to spell your last name and your address, if you would, and then I'm happy to share your comment. Any other public comment on definitions? Any feedback on any of these? Looks like I have something here.
We
Yes.
still need an address. Oh, there we
got it.
go.
All right. How do you want to do this? Do you want me to read these? I'm happy to do it, or do you prefer to read them, staff?
I can read it.
Okay.
So Nada, and I'm sorry, I don't know how to pronounce your last name. Nada from 32 Webster Street. I would say if you knock down an entire building after obtaining conditional approval of your project, that does not include demolitioning a building, that would and should be considered a major alteration.
Thank you. I would tend to agree. Yes, so that's a good example of an alteration to a site, right? Or to a structure and a site in many ways. Okay, any other comments from board or public at this point on definitions?
Yeah, I mean so the alteration, an example that would catch this is if a local business decided to, instead of using the landscaping that's there, put in gravel and kind of change the landscaping in a material way that, the town wants to be able to know what's happening and see how that would impact other things, obviously. So
Yeah, so with or without this bylaw change, if a commercial property owner can't did something to alter their property, the building commissioner would determine it was a site alteration. This just puts people on notice on what is and isn't a site alteration.
I put an example on the screen of where the bylaw uses alteration. This is section 7.2 EIDR. So you can see they say it's applying to municipal, institutional, commercial, industrial, multifamily property. So it's not changing how we do anything. It's just clarifying what alteration means when it's used in the bylaw.
And the term alteration is used elsewhere. For instance, pre-existing non-conforming uses. There's a procedure for what you would have to do. You have to go to the Zoning Board of Appeals if you wish to alter a pre-existing non-conforming use or pre-existing non-conforming structure. So same thing. Wherever the term alteration appears in the bylaw, it is now, you can look at that definition, which the way it's currently in the zoning bylaw prior to this change, when you look at the definition for alteration, all you see is a definition with regard to a building or structure. So it's just an area that is not yet defined. So they're defining it so that everyone's on the same page as opposed to just waiting to hear what the building commissioner determines is an alteration.
Thank you. Any further discussion on PB4, the definitions, or are we comfortable with the language as presented at this time?
I would just like to point out one thing. You had a question that you asked me to check with town council having to do with the next portion of this article, which are changes not just to section 2, but changes to section 4.15 and 4.32. These changes add definitional titles to the use chart. So where we put in a new definition for electric vehicle charging facility, we're adding to the use chart an electric vehicle charging facility and showing that it's only allowed in the highway business district.
Yeah.
Where we have accessory electric vehicle charging station, we're showing that that is allowed in local business A, B, highway business, industrial office, and ARO. So if we did not have these use chart additions to the bylaw, the terms would be defined, but it wouldn't be clear where they were permitted and where they were not be permitted. And since we are removing the electrical vehicle charging facility from motor vehicle light service, which is already in the use chart, it makes it an orphan. So it doesn't, if we didn't add these use chart changes, it would not be clear where they were allowed or where they weren't. So you asked me to check with town council to make sure that wasn't beyond the scope of the advertised article. I checked, and Pat Ahern's position was that because we have this language or take any other action in relation thereto, the proposed changes to section 4.1 and 4.3 are in relation to the section 2 definition changes. So he thinks it is within the scope of the article.
Excellent. Thank you for following up on that. And it sounds like we're okay to proceed.
Sorry, Ellen, I have just one, I just want to make sure I understand. So Nora, so the definition of electric vehicle charging station, a freestanding or structure-mounted means of providing power to an electric vehicle. And then when you look to the accessory electric vehicle charging station that is accessory to residential, whether or not it's pay to charge. Would this cover, like the Tesla charging stations or charging poles that are on people's property?
So it would, yes. So those, if they're on your residential property or even on a business property, those would be accessory electric vehicle charging stations, and they would be permitted. Now, an accessory electric vehicle charging station here is a pay to charge. I'm sorry, it says whether or not pay to charge.
I
Okay.
just want to make sure that's not covered because we're not trying to regulate the Tesla stations on people's properties right now, right? The Tesla.
We're not trying to regulate individual ones on residential properties, but what we're trying to do is make sure that an electric vehicle charging facility, whether it's a Tesla facility or some other facility that sets up more or less like a gas station that provides electrical charging, electrical fueling of cars, we're trying to make sure that those facilities are limited to our highway business area, that we
And-
don't see those pop up in residential zones.
And I'm just
Or
wondering,
business zones.
and others chime in, is this, the way I read this, it would be covered because it falls under the definition of electric vehicle charging station. And then it would appear to fall under the definition of accessory electric, right? It's an electric charging station, accessory to a residence, whether or not it's a pay to charge.
So I'm thinking that that probably shouldn't say residents. And we have Mike Perkins here. He had prepared these definitions. I think if we removed, I think maybe what we would do is put in a disclaimer that it would not include an accessory vehicle charging station at an individual residential unit, but it would apply to ones at a multifamily residential unit. I think they're just a little bit different.
Mhm.
Mike, do you want to weigh in on what your intention was with this definition?
Yeah, Mike, if you could jump in, because that would be helpful.
Yep. So this is essentially, like Nora was saying, trying to capture, again, Mike, like you were saying, like a Tesla supercharger station that you see sometimes on the, they have them in New Hampshire at the rest areas. Some places have them, accessory to or on the property of different businesses, things like that. That's what it's trying to capture, because right now, the way the zoning bylaw is written, any vehicle fueling falls under motor vehicle light service, whether that's electric, whether that's diesel, whether that's gas, whether that's some years ago there was a hydrogen fueling station that wanted to come into town. And so the way that the zoning bylaw defines that, it's all encompassing as anything that provides fuel to a vehicle. So the intent of this is to pull electric vehicle charging stations that, I guess, like Nora was saying, like a gas station that you pull into, you plug in, you charge, you pay for that, and then you drive off. Those would be removed from that motor vehicle light service.
Yeah.
It's not intended to encompass, the charging stations at your house, or that are, you've got 2 or 3 of them in a office building parking lot or something like that. It comes into play here where the energy code and the bill, so the building code, and by extension the energy code, especially the stretch energy code, now require EV charging stations at new construction facilities, whether that's, I think it's right now multi-family residential construction requires 20% of all parking spaces to be EV chargers. There's different requirements for different types of facilities, but this is trying to capture, I don't want to say standalone, but ones that are clearly not associated with a business, an office or something like that. If you've got a, 30 space Tesla supercharging station, that is clearly not associated with the office building at that address. That is made to essentially be a for-profit business charging vehicles. So that's what the intent behind it is to pull the electric vehicle out of motor vehicle light service so that they could be constructed in several different locations.
So if you look at the language I just changed on the accessory electric vehicle charging station, I'm changing to say where the station is a pay to charge electric vehicle station. If you have one just at your house where you're not charging anyone to use it, that would not be covered. That just wouldn't be addressed. That would fall under the third definition, electric vehicle charging station, but it would not be regulated in the use chart. It would not be something that we say you can or cannot have. An accessory electric vehicle charging station, perhaps think of 101 Station Drive. I think they have some electrical charging stations, right? Or the hotel, for instance. The
Yeah,
hotel that's going into construction will have charging stations, but their business is not to be an electric vehicle charging facility. They just have accessory vehicles charging stations there, and those would be regulated, and they would be allowed uses. In that case, that's in the industrial zone.
yeah. I mean, you might consider doing that work in the definition of electric vehicle charging station itself, just by exempting, one that's used, at a residence for personal use or whatever. Because the way the accessory still reads, if some big company wanted to provide this service for free because it gets people in the lot and they look good doing it and whatever, they wouldn't be covered under this bylaw, right? Because it has to be for pay. It's a
Right.
hypothetical that probably wouldn't happen, but um, I don't know if just exempting the residential use and the other definition is easier.
Okay.
I
Does
was
that make
actually thinking the same because in some respects, just listening to the discussion, it was striking me, it actually might confuse it a bit more. And I don't think that's our intent.
They're not.
Laura, can you zoom in a little?
What's that? Zoom
Can
in?
you
Yeah,
zoom in
if
a
you
little
could zoom
bit?
in because I'm struggling. It's a little small. Much better, much better.
So just to clarify, the intent here is to allow accessory EV chargers basically in the parking lot of an office building, business, a bank, something like that, where it was whether or not they're pay to charge or not, because we have some at town municipal buildings that are free. Some of them are charged, but they're clearly not the primary use of that property is not to say, hey, come park here, charge your vehicle, and then take off and leave. So if again, it gets into the zoning bylaw not catching up to the building code, to technology, to energy codes. They're required now in certain aspects or certain areas of construction or renovations. We just want to make sure that our zoning doesn't conflict with those requirements going forward.
Does that edit capture, Mike, Phil, what you were going for there?
I'm wondering about the word occupants or personal use by occupants.
Owners.
I was going to say, well, because you might have tenants. Um,
Would occupants cover that, Phil?
Occupants would
Occupants.
cover tenants.
No, I know, but what if you own, but you don't live there?
You're still the occupant.
Owners or occupants, yep. Then that covers tenants and the owner because you could have both. All right, I like that better.
So this
Yeah.
would allow you to have a charging station at your home or at your business, but it would not allow you to have pay for charge stations that aren't necessarily associated with your business. Pay to charge stations for customers to use. That would be something different.
Yeah, this looks good to me.
I think I'm wondering if we should change the word occupants to tenants. I don't know that tenants implies that I mean, if a tenancy is created, I would prefer that as compared to just an occupancy. I think tenants, otherwise, then I'm happy with it. What do you guys think? Tenants a little better?
I'm
I
gonna
think so. Yeah.
defer to you guys.
Mike, what do you think?
I think it covers the same thing. I think it's fine.
And I was wondering, what's the difference between an occupant and a tenant?
So the
Squatters.
technical difference is who's financially responsible.
So
For
squatters don't
example,
get rights.
So like if you have, say,
Okay.
a child who drives, they would be considered an occupant, not a tenant, because they're not on the lease.
Oh, so like your 16-year-old.
Correct.
Okay.
I mean, could you say just residents? Does that cover everybody? Are they a resident of that?
You have a guest. It's not a tenant.
You want to limit it to just the people that are either living
Yeah.
in the,
Yeah, personal use implies that if their friend wants to use it, that's personal use, right? It's
Right.
I think we need to get too in the weeds. I'm fine with this definition the way it's written.
Yeah, because then you get into invitees, and we don't need to really go down that.
that rabbit hole.
Yeah, just I'm good. I'll echo Mike.
Yeah, I'm good with this.
Okay. Any further discussion on that? It
I
sounds like
just
we
have one question from Mike Perkins.
yes.
He's still there? Yeah.
There you go.
I'm here. Fire away.
Yep.
I just have one question for you. When you were saying 20% requirement by the stretch code, what size building? Or is there like you have to have-
Anything over 2-family structure is considered a commercial building under the building code. So 3-family and up, however many off-street parking spaces you provide, 20% of those are required to be have EV chargers associated with them.
So if there was a new building that went up, but that was a 3-family,
Yep.
you would be required to have.
You would have at least one of those would have to have an EV charger associated with it. And the intent is so that tenants of that building could use that EV charger to charge an electric vehicle. So for instance, at 22 Everett Street, there are, Amanda, Nora, correct me if I'm wrong, I think there are 28 parking spaces that have EV chargers in them. They're not specifically reserved. You can't reserve them like a handicap or accessible parking space where it's permit only, and you can say, you can get a ticket or get towed if you don't, have an EV vehicle or EV car in there. Redundant, but yeah, there's provisions in the current code and going forward that are going to require more and more of these EV stations throughout residential, non-residential. If you build a new house now under the current stretch code requirement, you have to have at least one EV charger provision in your garage or parking space. You don't necessarily have to have the plug there, but you have to wire it in your home for someone in the future to potentially put one in. So yeah, that's currently right now the only requirement for multifamily is anything over 2-family or 2 dwelling units on the same property requires at least 20% to be EV chargers.
Thank you.
Thank you. Any further discussion either by board members or staff? I mean, sorry, or the public on the definitions or any of what we've been discussing, EVs or otherwise at this time?
I'm
Again,
good. I think it's good.
Yep.
Yeah, I appreciate the input on that verbiage, so thank you all. And again, if something pops up in the Q&A later, we can loop back to this, but I'm not seeing anything else. So if board members feel good about this, I think we could move on to PB5, zoning bylaws amendments relative dimensional regulations.
All right, so PB5 recommends changes to the definition section related to building height. And it recommends adding a sentence at the end of the definition of building height to state, notwithstanding the above, the height of any portion of a building or structure which is permitted within any setback area pursuant to notes 5 and 7 of section 5.3 shall be determined by the measurement of an actual dimension from grade to the highest point of the portion of the building or structure within the setback. And then the images are shown to define how that would be measured. The first two images are existing, showing how an average height is measured, and the third set of images would show how the portion of the building height would be measured. So we discussed this quite a bit at the last two hearing sessions. This is intended to clarify the way the current bylaw is interpreted with regard to notes 5 and 6, which allow building within the setback areas. So to give you just a little bit of history on this, our zoning bylaw has allowed buildings to extend within the setback areas for the residential districts up to 5 feet into the setback areas since at least 1961. So this is a very long-standing provision. It's now done through footnotes. In the past, it was done in other ways, but the language was clearly in there going back as early as 1961, allowing SRC and SRE districts, which have 20-foot side setbacks, to have those reduced to 15 feet as long as the height of a building did not exceed 15 feet, the height of the portion of the building in the setback. And in single residence B, A, B, D, and general residence, which had a normal setback of 15 feet, it allowed the building to go up to 5 feet into that so that the setback would only be 10 feet, as long as the height of the portion of the building within the setback area was no higher than 15 feet. So although this goes back to at least 1961, and it could be beyond that, I haven't pulled all the zoning bylaws before that date, but although it went back that far, 43 years after that provision was put into the bylaw, building height was defined. So building height was never defined as an average height for the first 43 years of this allowance to have buildings put in setbacks. So when our zoning bylaw first added this section, town meeting voters thought it was appropriate as long as the height of the building was no higher than 15 feet. So what the board should do is discuss now. Do they believe that voters still feel the same way? Or do they feel that voters have changed their opinions over time about how this provision should be applied? But it was always intended to apply to the height of the building, period, not the height of not the average height of the portion of the building what's in that area. So a definition for building height, citing average height, was put into place in 2004. It was amended in 2014. It was amended again in 2015. And most recently in 2024, the illustrations that I just showed you here and here were added to explain what building height was. But it was never intended to affect the height of the portion of the structure that falls within these setback areas. So the building commissioner that we have today, Mike Perkins, has interpreted this based on the origination of the allowance to go into the setback areas. The prior building commissioner did not interpret it that way. The prior building commissioner is the one who introduced the average height definition that was not in place for the first 43 years of the allowance of buildings to go into setbacks. So the bylaw has changed over time. Every change comes about because 2/3 of town meeting voters support that change. And in most cases, the changes have started with the planning board's recommendation. So that's where we are today. You have the recommendation that the building commissioner has sent to you, and you have heard from residents who feel differently. And I think it's before the board to decide which way you think voters will support and what way you think is most appropriate for Westwood's future development.
Thank you, Nora. Excuse me, before I start board conversation, I want to take time to thank both Mike Perkins and the contingent of residents who took the time to put together illustrations and photographs and a ton of information to share with us. I personally found it very helpful. So thank you to all of you. And I also want to acknowledge that we did receive a petition from residents in some of the neighborhoods that would be potentially most impacted by this change. So we did receive that. And again, thank you for your efforts to take the time to share feedback with this board. It is appreciated. So I just wanted to acknowledge all that before we jump into our discussion. It provides a little context as well. So I'm happy to open the floor to board members. I have some questions and comments on this one, but I will hold mine till the end, as I usually do. So board members, questions, comments?
I would ask if Mike had anything to add, just in light of some of the information we had.
Perfect, yes.
That we had gotten.
Yeah, thank you. We do have our building commissioner, Mike Perkins. Mike, I think per Phil's salient point there, I will open the floor to you if you'd like to share anything first.
And I was going to ask if he wants to go through the materials he submitted. Some of those are really helpful, but he can just kind of like point out the things that we should be focusing on there.
Excellent.
I think that would be helpful too. I agree.
Okay.
If you don't mind.
Do you want me to pull it up, Mike?
Not to put you on the spot.
I guess if
but
you
we're
can,
gonna put you on the spot.
I'm here, right? Like, so I know at our the last planning board meeting, there was a request for examples or potential examples of things that could be done, depending on which, if any, amendment was adopted to the bylaw. So the background is that, as Nora said, the zoning bylaw has these two notes to the dimensional requirements table that talk about allowing buildings to encroach 5 feet further into the side setback or being closer to the property lines than a quote unquote standard or normal building would be. And my interpretation of this has been that the intent is to allow buildings to be closer to the lot line or the side lot lines if they are smaller in mass, meaning height, and by definition, the building itself being less massive as it gets closer to the lot line. I have always thought that would be a hard and fast, put the stick on the ground and take a measurement to whatever is above that. That is the definition of height for that portion of the structure, meaning that would be 15 feet or under. So again, I know you have seen this. I don't know, Amanda, if you can scroll through a couple of these slides or keep going. So this is just an example. 218, 224 School Street. This is a house that on the right, you can see 224 School has what would be termed a garage under. It is a lower level garage, so to speak. It is very close to that 10-foot setback line. It is beyond that 15-foot setback line. And what is it there? 20 foot, 28, just under 29 feet between the two structures. And then if you go to the next slide, it's a kind of a Google Street View showing what the existing conditions are. Again, it's very close to that 10-foot line, or in the back corner, it's beyond it. And then you can see there that 15-foot setback line. But again, the thing that we're talking about is the height. So the average height definition talks about the high point of grade adjacent to the structure. That's where that orange line is. The top right, I guess, corner of this house is the high point of grade. So that's where we would start the, 0.0 measurement from and go from there. If you use that, obviously you measure from that point up, and per the definition that we have for average height, you base it off of that line. Amanda, if you want to go to the next one there. So with the actual height measurement for that intervening section between the 10 and 15-foot setback lines, you would then take the measurement from the point of grade adjacent to that 5-foot area. You wouldn't use the average height line, which is much higher on this particular property. So again, you would measure up from that bottom, of the garage door, essentially on this house, measure up. If it's 15 feet, you're allowed to be in that 5-foot area. If you're over 15 feet, you would not be allowed to be in that 5-foot area. So if you go to the next slide, Amanda, if you use the average height definition, you again use that high point of grade adjacent to the house, and then you would average the peak and the essentially the gutter line of that roof line, and you average those out, and this would be 15 feet in that 5-foot setback area, that intervening 5-foot stairs area. Looks like Tim, I don't know. Do you have a question for me or someone else on the board? Or
Sorry, quick question. If you
Yeah.
go back, so is the just so I can understand, the slide prior is this is the example, but the delta between these two slides is what would be allowed for them to do an addition at this house on the left side of the house, correct? That's the
Correct.
maximum.
Yes.
Anything beyond that is not okay.
Correct. So right now, the way that the bylaw is worded, it talks about the height of the portion of
Yep.
the structure in that 5-foot area, and so that's what this entire thing
Got
is
it.
about, is trying to provide clarification. This
Yeah.
is when I read it, this is what I read it as, and so obviously clarification, less confusion. That's a good thing. It's just
Yeah.
trying to say this is what we're talking about here. But again, if you go from this, so that's the existing conditions. If you go to the next slide, that would be the allowable.
Sorry.
That would be before it. Yeah, that
You're
would be
killing
the
me. What are you doing?
Yeah.
that would be the allowable addition under the actual height interpretation, and then the next slide, Amanda, would be what could be constructed with the average height interpretation or definition.
Got it.
So I actually lied, because while we have these pictures up, I'm not going to hold this comment because it's actually a question. Amanda, if you could go back to the previous slide. Let's pretend, because it's easier for me to ask my question with a visual. Let's pretend that that's not an addition. Let's pretend that that's an existing house that has an existing nonconformity. It's into the setback already. Under the bylaw that allows you to extend an existing nonconformity, could they do what you showed us on the next slide?
So you possibly could. It depends, and I think I said this at the last meeting, is if you have an existing nonconformity on your property, the zoning bylaw allows you to, quote unquote, get away with more. You can modify, extend, and in some cases increase a nonconformity. It depends on what that is. So if you have a wall that is, let's just say your house is too close to the front property line, if you want to extend that vertically, you could go to the ZBA and have that approved via special permit. If you were to expand that vertically and horizontally, depending on the impact or how large that expansion would be, then it's up to interpretation as to whether or not that is more detrimental to the neighborhood. Usually, if you're increasing both a vertical and a horizontal, so let's just say you increase the footprint and the height, that typically would require a variance, not a special permit from the ZBA.
No, I understand. I guess like if I have what's on my screen now and I want to build what was on the next slide, because in
Mhm.
this case, I'm
Yep.
talking about an existing nonconformity.
Yep.
It sounds like I could then apply for a special permit to go up above what I already have, even though it's already into the set. What I'm getting at is I'm trying to ascertain if people who have a currently conforming lot can actually do less, because that feels like there's some inequity there. If someone
Right. So
happens
it's
to have an existing
I was just
nonconformity,
gonna say the same thing, Ellen. That's an
thank
excellent
you.
question.
That's
Excellent,
what I'm trying to
excellent
get
point.
at, because that doesn't feel okay to me. That's just, and again, this is just, I understand we have certain rules for existing nonconformities, but it feels like if someone has this house and it's conforming, if this footprint were conforming, they wouldn't be able to do as much as they can with a non-conforming lot. So I'm just trying to tease this out. And am I
Yep.
understanding correctly?
Yeah, so it's not the lot itself, it's the structure.
Okay.
So the non-conforming, if you have a non-conforming lot and you have a house built upon it already, then you're still tied into the same restrictions for setbacks and height as you would be for a new construction house on a conforming lot. If you have a non-conforming structure and you want to modify the existing nonconformity, there are provisions in the bylaw to allow that to happen via special permit, sometimes by right. But if you have a conforming house, meaning, you know, in this case, if you're totally out of the 15-foot setback and you said, you know what, I want to expand into the 15-foot setback, that's a different story than my house is already 12 feet off the lot line. I want to modify that. So it's one of the, again, it's a quirky thing in the bylaw that allows modification to an existing nonconformity. Whether or not that is something the board wants to take up or not, I doubt at this time, just given given where we are.
Right.
But it's one of those
But-
things where if you have an existing nonconformity, you can modify that portion of the house. Whereas if you don't have an existing nonconformity, you can't create a new one.
Well, that's kind of what I'm getting at is like so for a one-for-one example, some of these homes, and I understand that I mean I have houses in my neighborhood that are on non-conforming lots, but the house itself conforms to the setback. So for context, that's what I'm talking about. I'm not talking about the lot itself, but if the property, if the home, if some of these projects where you've had to interpret the bylaw because their house happens to conform to the setback, if it had been an existing, if they were at 10 feet already instead of the 15, they would have a better chance of being able to go up above the 15-foot height limit. I'm not sure if I'm articulating this well, but it seems like a victim of circumstance. The house could be the exact same house on the exact same property. And if it were 5 feet to the left or 5 feet to the right, they would be able to do some of these things that the section of the bylaw that we're talking about now potentially prevents them from doing.
And that demonstrates inequity. I was just gonna, Ellen, this is an excellent point, because that demonstrates inequity in terms of what we're doing. And I'm not now getting, the visuals actually make this
Yeah.
a little bit more
But-
recognizable.
Mike, do you have
I-
context for just for a sense of understanding, roughly how many houses in some of these smaller lot neighborhoods? Because I mean, I live in one of the in Islington area right here. A lot. I imagine there's a decently large number relative of non-conforming structures. Do you have a sense of
So
percentage wise or?
structures themselves, I would have to do a little bit of research on it. I would say probably in town, at least for lot size, the number of lots in town that are non-conforming is probably someplace between 60 and 70%. and that usually historically in Westwood and other municipalities is intentional.
Yeah.
You basically you create the zoning around what you have so far and say, you know what, we want to make sure somebody can't subdivide this lot or can't put two family on this or whatever it may be. So I would say probably at least 2/3 of the lots in town are non-conforming for area, frontage, things like that. I would say I would say maybe 30 to 40% of structures in town are non-conforming one way or another, whether that's front line
Yeah,
setback,
that's
rear,
right.
side. These two notes are referencing the sideline only. They don't have to do with the front or the rear. So if you're, you know, if you're in the front setback, you can't bump forward 5 more feet or something like that. These are only regarding the sideline setbacks. So I agree. It's one of those things. Like I said, it's a quirky thing where if you have a non-conforming house, you can modify it. I think the intention there was to say we've got a lot of non-conforming houses, so we can allow those to be modified. Again, every
Like,
town, every municipality does things differently. Like there are certain towns where if you've got a non-conforming lot and a non-conforming house, you can't touch it.
if I can just point out that's the way it used to be in Westwood, and I'm thinking it was sometime within the last 10 or 15 years that the bylaw was changed just to create that inequity that you've mentioned. That was intentional. The planning board recommended that, and town meeting voters supported that to give a leg up to people who had non-conforming structures. And there were various reasons why people who supported that 10, 15 years ago. What I haven't researched it today, so I don't know the exact date when that was approved, but there was a fairly heated discussion at the time. And people who were supportive of that believed that it would result in fewer tear downs by allowing people who had non-conforming structures to renovate the structures and put additions on. And the thought that the people who supported that had said was that they believed that it would be sufficient, that they would go before the zoning board of appeals, and in cases where neighbors objected or there was something that was concerning about the proposed structure, they would have an avenue there. People who objected to the bylaw change back then did so for the reasons you've brought up today, that it creates inequity, that someone whose property is right up to but not over that setback line has less opportunity than someone who is just an inch into that setback line.
Thank you. Yeah, I remember those conversations. It was, I think, prior to any of our time on the board, but we talk about unintended consequences a lot. And
Exactly.
I remember around the tear down thing. So, and I think at the time that made sense, but now what I'm hearing is, and again, I guess I'm talking before I've let everybody else talk, but to just it's timely. What I'm hearing from the community is that two houses could be next door to each other and one of them happens to conform to the setbacks and the other doesn't, and the one that doesn't can actually build the addition that allows their family to keep growing and stay in the house they're in and not tear it down, whereas the house next door either has to tear down and start over, and that may not even solve their problem, or they're looking at having to find another neighborhood, or so again, like
This
this is what
doesn't
I'm
solve.
trying to tease out and weigh in my head about. I we talk a
Or
lot
it
about
creates,
trying to enable people to stay in their homes. And I think we've talked about that in the context of people who are retiring and looking to downsize. But I think that can apply to people who are trying to grow too. So I'm I'm not trying to critique what we did before, but I think this may be 10, 15 years down the road. We're seeing that there may be an inequity here that is becoming more impactful. And this is why I'm glad we're having this conversation. And these visuals are really helpful because that was a big question for me. Are people who are currently not conforming to the setback able to do more than people who are? Yeah.
So
And
And this
that,
is the unintended consequences that we don't want to create a problem or inequitable solution to situations. And that's some of what we're talking about right now.
So I just want to point out, it was intended, not unintended consequences. That was the intention of the bylaw change that allowed that to happen.
Hmm.
And if this board feels that that was inappropriate, you could consider a bylaw change that allows a special permit for incursion into the setbacks for conforming as well as non-conforming structures. That would be a different bylaw than what is being discussed today. What's being discussed today simply has to do with notes 5 and 7 for extension into the setback areas.
And the published notice probably does not cover this.
I will take a look at it. I think it probably would go beyond the scope of that advertised article to alleviate the need for a variance for a conforming structure. I think that would be a different article, but
Yeah.
I will check to see how the advertisement was made.
Thank you. But I'm mindful of the fact that if we change the definition to hard code it in that it's from the actual height, then that leaves no possibility for some of these conforming structures to be able to even extend to the existing roof line of the rest of the house. And that's kind of what I'm struggling with. So, but I see Maureen has her hand up, so I want to let her talk.
No, you you spoke for me.
Well,
So I'm
gee,
good.
sorry, sorry.
No, that's good.
So I
It
did,
was kind of like I said, damned if we do and damned if we don't. Huh?
Well,
I
I
did-
will say the visuals make it all of a sudden very striking,
I kind of like this one better, but
apparent.
So I checked how the advertisement was written, and this bylaw warrant article references specifically the height of a structure in the setback under notes 5 and 7. So you are limited to that. That
Okay.
doesn't mean you couldn't take up another article in the future if you feel that it's appropriate to allow special permits instead of variances for conforming structures.
Thank you. I see Mike Perkins and Tim. Tim, if you don't mind, I'll go to Mike first and then we can go to you.
Yeah, I was just gonna add that if there is an appetite to address I guess inequities in specifically the Maze, Islington, general residence, single residence A, certain districts, things like that, it may be worth exploring. And I don't want to throw this out there for the board to take up or anything like that, but if that's the intent, there's more opportunity in revising the setback requirements for specific neighborhoods and or lots. It would be a little difficult to tease out, if you've got a conforming house and a conforming lot in the Maze neighborhood, could you not do something that a non-conforming house would you tie it to frontage setback? If you're similar to our average height, you're allowed an extra foot for every foot that you're out of the setback requirement, things like that. It would be a little bit more complicated to tease that out and do it that way. But if the intent is to, or the board wishes to pursue something along those lines, I think it would be a little bit more complicated and nuanced than what we're talking about these two footnotes here today. I'm not saying that's a bad thing or not. It's definitely something that's worth looking at. It would just take some legwork to figure out exactly how that would be done.
I think actually it would take a lot of work, Mike. I think between the Maze, Islington, and it would be a lot of work. And I don't think I don't think we have the bandwidth between now and town meeting this spring.
Yeah, I think that's maybe for the future. I'm just trying to figure out what we could and couldn't and should and shouldn't do now. And I have a few more thoughts on that, but I want to go to Tim first.
Let alone, I think that's going to be an even more of an uphill battle when people start to talk about setback restrictions. And I feel like that would be rather contentious, I would imagine. I guess maybe first off, I just thank you for these visuals and the community visuals, because to be honest, the visuals that are currently in the proposed bylaws, I maybe I just was completely missing it, but this brought it to light a lot. So I don't know if that means that however we end up defining it, maybe we should think about different visuals shown on the actual bylaws. I would just ask, is one of the, equities aside, is one of the unintended consequences, I don't know where you're talking about intended, an unintended consequence here, though, right? Like you're then promoting different types of renovations and structures that are, you're moving everything more towards the middle. Is that it? What's the current, maybe, and if you could just help me understand what are some current limitations on height outside of setback areas, and are we incentivizing people to then just build, upwards larger? That would be helpful to
So
understand.
I don't think the intent, and I don't think the vast majority of um, renovations, additions, structures that are constructed to meet the current setback guidelines. I don't think the intent is to keep them going up versus out. It is more or less to protect the properties
Yeah,
adjacent to a property.
but that will create, if you need space, right? You would then go up outside the setback areas.
Right.
Mm.
And usually what happens in cases like, let's just say this house here, and I
Yeah,
don't have the plot plan in front of me to see exactly what's going on. In most cases where there's a house like this that's very close to the sideline setbacks, the house goes back. Because our height restrictions are 25-foot average height, where you see those two dormers on the roof line of this house, that's about that's going to be close to 25-ish feet, maybe 22
okay.
right there. So you could maybe make that a two-story house with a peaked roof above it. But for the most part, houses go back away from the street. So so like on this one right here, we say, it's 28.7 feet to the neighboring house. The intent is that it's not a code requirement. It's obviously a zoning bylaw. It's a Westwood thing where at a minimum you would want 30 feet between two-story homes. So 15 feet on either side of the property line. That's what that setback requirement basically shows right there.
I'm pulling up the aerial.
Does that give you the context you were looking for, Tim?
Yeah, thank you, Mike.
Yeah, so usually and just speaking from, some anecdotal evidence from us, usually in the building department are, I don't want to say chief complaint, but the calls that we get or the visits that we get to people to our office are saying,
Yeah,
how
same.
come this person
Yeah.
could build this two-story monstrosity really close to the property line? And we
Yeah.
say,
That's helpful. Yeah. My question is
sometimes
then, that shift it to then be a higher monstrosity in the middle, and you're going to get similar
right.
complaints.
So that's the thing is, so like I had a person the other day come in and said, why could this person build a house that's this tall 20 feet from the property line? And the reason is because it's by right, it's a 25-foot high building. That's the average height of the house. They're allowed to do that by right. There's at least 20 feet between that house and the property line. If you were to remove that 20-foot or 20, that 5-foot restriction where you're saying we're dropping it down to actual height, that would be a much less massive house next to the property line. But again, it depends on what you want to. Do you want to allow owners of houses that are non-conforming existing to be able to expand, build up, build out, build behind? But then do you want to protect the neighbor that is 5 foot off of that property line from their neighbor encroaching further into their house?
But I'm sorry, but if I understand correctly, the person who's already 5 foot off the property line, that's I don't know any neighborhood in Westwood that has a 5 foot setback. So
Right.
that encroachment could already happen. But the person who's 15 foot off the setback couldn't do the same thing who's already closer.
Correct. Yeah, no, you're totally right. I mean, you could be 2 feet off the property. We have houses that are less than a foot off of the property line. And usually what happens is when their neighbor puts a second story addition on their house, they say, well, we didn't know that was going to happen when we moved in. Now we have somebody that has a second story window that looks out over our back deck and we have no privacy. Well, your back deck is already 2 feet off the property line. It's been there forever. This person can put a second story addition on by right. There's nothing you can do about it.
Right. But if that house was conforming to the setback, they couldn't necessarily go up a full second story in further into the setback. They could, 15 feet away, but if they're trying to put an addition on, they would be limited under what we're being asked to do to a 15-foot absolute height. So,
Precisely.
I have a couple of questions and I have a couple of suggestions just for the board and for all of us to discuss. My first question is, if we go with average height, is there a circumstance under which that would allow a home like this to go above its existing roof line or no?
Yes.
Okay. So that's something that I understand people don't want to see.
Right. So I don't know, Amanda, if you can skip way forward in these slides.
The A-frame.
Yeah. So this is the absolute, I again, put my worst case scenario hat on. This is the logical extrapolation of this. That house on the right, the way our zoning bylaw defines it, that's only 15 feet tall. It's 2.5-ish structures, but the way we measure height, that's 15 feet tall. That can get closer to the property line than that structure on the left, because that is defined as having higher than 15 feet average height.
Thank you. So I guess my question is, and this may just be because I'm not as well versed in building commissioner rules and regs, but do we have to say measured by, is there a way we could make a provision like, average height? Or I'm hearing there are people who want to go to the roof line and no further. I've seen a lot of examples. I've seen a couple in my neighborhood where people go to their existing roof line on the addition, and it doesn't seem like there's a lot of concern about that. At least, again, this is what I'm hearing. Is there a way we could bake it in there that if someone wants to go their existing roof line within 5 feet into the setback, that's not going to be a problem regardless of where we start the measurement from, but anything beyond the existing roof line is something that you would not want to
So
see?
it depends. In most cases, yes, that usually isn't a concern, because when you're standing on the street and you see the peak of a house, you say, okay, fine, they expanded it sideways, not that big of a deal. If you have, let's just say you live on the downhill side of a residence and their uphill side is only a 25-foot average height, but they match that going across the lot line, it might be 60 feet tall on the left side of the building. But because of the way we average the height, it's only considered a 25-foot tall building. You might have 3.5 stories, but it's only 25 feet tall. That's allowed. So I think about, again, and I know people, I don't want to bring it up, but the former FS1 design on High Street, that building was not 67 feet tall, but from the back side of the property, it did look like it was 67 feet tall. But the way we measure it, it was not. Same thing. I think about houses on, some of the bigger properties in town, some of the houses on Grove Street, Summer Street, things like that, Far Reach Road, those types of neighborhoods where you've got larger houses. They may be 3.5 stories tall. If you were going to say it's okay to match your existing roof line into that setback distance, then it becomes a worst case scenario, extreme case, where you're saying we want to limit this or we want to allow it all. It
This
just
is a good
depends.
segue. Because you're touching us at like Grove Street, it's almost a 2 acre lot. And even though I know that most of them have almost that. So that's kind of where I landed. I thought on this a lot. And my current thinking is that we're talking about a one size fits all solution, and I'm just not convinced that that's going to work. Because there's disparity between a house on Grove Street and a house on School Street. I looked at the three smallest required lot sizes are in SRA, SRD, and the general residence. That's 12,000 square foot, 15,000 square foot, and 12,000 square foot respectively. I'm interested in, is there a desire and a way forward to maybe have one set of requirements for the smaller neighborhoods that would be most affected by capping this at 15 feet for them, and something like a E or a Grove Street, or that has far more room to actually build something appropriate. I'm not articulating this well, but I'm feeling like
No,
there's
I understand what
You
you're
are.
saying, and I think so. All our zoning districts have different setback requirements, lot size requirements, coverage, things like that. I mean, the easiest way to do it is to either A, remove those two footnotes or those two notes from the table of dimensional requirements, and just say the setbacks are the setbacks, and so be it. Do what you can from there. Like Nora was saying, change the encroachment into the setback or a new nonconformity from a variance to a special permit, so that you wouldn't have to prove the hardship and topography and geology, things like that. Or it's across the board, just say you can get 5 feet closer to your lot line by measuring the average height has to be 15, 20, 25, whatever it may be. One way or the other, there's a lot, as Phil said, there's a lot of different ways to do it. There's a lot of work that can be done on it. I'm not sure the most equitable way to do it and what would come. And again, it depends on what this board wants to do. Is it to allow expansion of smaller homes on smaller lots? Is it to allow expansion of all homes on all lots? Or there's a lot of if thens. There's several ways to approach it. I can't tell you the right way to do it. I'm not trying to tell you the right way to do it. Any way would require a little bit of research and doing, because again, you would want to find out what percentage of homes in the maze or Islington, fall under non-conforming versus conforming. Do you tie it to, like we do with conversion of existing family homes to two-family homes, where you have to have at least 4,000 additional feet above and beyond what the zone requires for square footage on a lot? Do you say if you have more than 2,000 square feet above and beyond what is required, you're allowed to do X? Do we want to institute FAR in residential districts? We don't have that right now. A lot of towns do, but we don't. I mean, that gets back to lot coverage and how many square feet you can build for a home versus how many square feet of a lot you have. There's a lot of different ways to go about it.
One
So
of the things that this is illustrating is, for my perspective, has always been clarity. And clarity in some respects is important. But when you are considering, I mean, the Maze or Islington, vastly different than other kinds of neighborhoods and whatnot. And the unintended consequences that are coming out of this now with, greater clarity. I don't think the entirety of this is to, either impose equitable constraints as compared to which may just be a far more in-depth discussion and consideration than what we've been considering up to this point. This entire process has raised, significant issues in my mind.
Thank
So-
you. If I can, sorry, I just want to make sure I understand, like, what if we endorse the change that you're asking us to make and move forward with the change, then that's it. It's capped, it's arbitrary. It's from the measurement is what it is. If we don't make that, and there's no appeal, no one can appeal that decision. It is what it is. If we don't make that change, you may still interpret it the same way, which is absolutely your purview, but someone who's put in a set of plans still has the option to go to the zoning board and appeal. Do I understand that correctly?
Yeah. So essentially, I mean, uh, to put it bluntly, or not politically correct is not the right term, but it matters not to me what the bylaw is. I enforce the bylaw as I see it and as I read it and as I interpret it. So in this case right now, the way the bylaw stands, my interpretation is that portion of the building within that 5-foot area needs to be under 15 feet tall. And that means putting a tape measure on the ground, putting it up 15 feet has to be less than that. If this board wants to adopt something different or change the wording to say, no, it's an average height, or no, it's 20 feet, not 15 feet, or it's an average height of 25 feet, which the rest of the bylaw talks about for building height, then that is this board's purview. I don't mind that change. I will enforce the bylaw as I interpret it as written. If it's codified as a clear, defined number, definition, whatever you want to say, then that's what I will do. But yes, if you adopt or recommend the adoption of the bylaw change as it's proposed right now, then it would be codified as a hard and fast 15-foot measurement. And there would be really no appeal on that. If it is not adopted and it stays as it is, then there would be an opportunity for a resident builder, developer, owner, whatever you want to call it, to then appeal that interpretation to the ZBA.
Thank you. I just wanted clarity on that to
Yep.
make sure that I was
Yep.
understanding.
That's very helpful.
Thank you. All right, I know Amanda's been waiting, and then I saw Tim and then Mike, so we'll go to Amanda.
Yeah, so I just wanted to point out something that actually came up when Mike and I were going through this presentation as we were trying to figure out how to communicate it, or Mike figured it out, just I'm not taking any credit for that. But usually what happens when people are informed of what this is interpreted as, they just go back to the drawing board and find a different place to put that addition. So for example, maybe you can't go to the side, but you can go back. So a lot of times it's not necessarily limiting what the amount that they can do, it's just where they put it. Not in all cases, but in many cases. So it's not as restrictive as it sounds on paper. For some lots, of course, that might be a different story depending on what is already there. But many times it's just, okay, we'll draw it this way so that we don't run into this issue.
Understood.
But we don't know the cost and the design. I mean, there's all sorts of other interpretations that come out of that. I mean, that could be a huge impact on a family's budget.
Well, most of them come early.
I don't think it's fair to have a sweeping, commentary on the examples that we've just had. If you show an example of there isn't room in the back either for some of those lots as well. So I hear your point that there could be other alternatives, but yeah, I don't know. To Phil's point that there's other factors. I just wanted to quickly say my philosophy here would be I know that technically the status quo is how Mike you're interpreting this, but I think we're understanding that this was previously interpreted a different way for a number of years. So maybe my recommendation, I don't know, I'm just thinking out loud, would be just to put into language how it was previously interpreted, because that was for a rather long time period, and then we can address some of these other issues if we want to change rules within certain districts or or whatnot. But at least when I think of status quo, and I think Mike, you made a comment about going to pushing it out to 5 feet. But I guess like within however many years ago, that kind of was already the status quo. So I just want to be careful how we use that terminology. I think the easiest way would just be to, rather than go the other direction and put in more restrictive language, might be easier to accept the broader language that was the norm for a number of years, and then kind of put our heads together in the next year when we have some more bandwidth to come up with a solution that more fairly addresses all districts. I'm just thinking out loud.
No, thank you. I think that's kind of the main, I don't want to say conflict, but the main kind of issue that I'm struggling with too. So I appreciate you um, sharing that. Um, I'm not sure who is next. Mike, you've been waiting. Oh, sorry, we have two mics. Mike Derderian, I saw you've been waiting, but then I also saw Mike Perkins' hand go up. So would you
Yeah.
like to hear from Mike before you speak, or?
No, let me just share quickly. So I think one of the things that has been going through my mind listening to this discussion is it is this sweeping rule, right? And I know the building commissioner does need rules to apply that, sometimes can be sweeping. But for me, applying, some of these examples and visuals we're seeing, how they look in the neighborhood really depends on what's around the house, right? Like, where do the trees look like? How high are the trees? What are the neighboring structures look like? I think all these things can impact, like how that addition is going to look. So I would almost favor some type of procedure where, even if we operate under Mike's current interpretation of the bylaw, there can be a mechanism that, if he deems that it's, amenable to, the neighborhood and there's no, big residential complaints, et cetera, that, the building commissioner could have discretion to maybe use the actual height interpretation over use the average height versus the actual height. Because I think how you use those, again, I think it depends on the context of the surrounding neighborhood, what the surrounding structures look like, what the tree lines look like. I could imagine, an average height, interpretation on an addition wouldn't really impact how the neighborhood looks, but in another setting it would. So I'm curious if that's possible, and if that makes sense to Mike Perkins. I'm curious what he thinks about that.
Thank you. And that's a good segue because Mike Perkins was going to be the next hand I called on.
So I guess two comments or two questions or two clarifications. If we want to codify things as they were done in the past, whether or not I agree with them, whether or not the board agrees with them, whether or not they were correct or incorrect, I think might set a dangerous precedent, because then it's, well, you did it wrong for 25 years. You might as well keep doing it wrong for 25 years. There are things where my predecessor and I disagreed upon. He was in charge, he was the boss, so we went with his interpretation. Whether or not this board heard of them or anything came before them or before the ZBA, I don't know. I can't speak to those specific incidents. And to your comment, Mike, about whether or not things affect the neighborhood or are, de minimis or more detrimental or things like that. There's a couple of places in the zoning bylaw right now where allow for that interpretation or determination. They're pretty narrow as far as an existing nonconformity being expanded or, moving. For instance, there's a case in town right now where there's a non-conforming house that was too close to the front lot line. They were moving it back, but expanding it over. It's basically a wash onto the square footage of the nonconformity. That's something that's spelled out in the zoning bylaw. If we're going to go with the building commissioner's interpretation, say I'm not here in 6 weeks, who knows what the next guy's going to say? He might say, you know what? Everything is awful. I'm not approving anything. Or somebody might say, go ahead, put 3 stories up. Looks fine to me. I came from Southie. So it's just that's difficult, because then you have no hard and fast rules or interpretations or numbers to go off of. So you would have somebody coming into our office in the building department saying, how do I design this house? And we would say, well, I think this would look okay. I think you could do this. I think you could do that. I would approve this. I wouldn't approve that. There's no real hard and fast rules to go off of. And that is, right now in Westwood, that's not something that's under the purview of the planning board. And basically in the zoning bylaw, the only thing that residential, single family or one and two family residential is regulated only by the dimensional requirements. If we start saying, well, it's up to the interpretation of the building commissioner whether or not this looks good in the neighborhood, who's to say, I like single story ranches. I'm sorry, you can't you can't build a 2-story house over there. It gets into a lot of opinion, interpretation, personal preference, things like that. So I would try to shy away from that, because then you have nothing to base it on, and you make it more confusing for people. If you say, well, if I plant 17 arborvitaes on this side of the house and some holly bushes over here, does that look okay to you? And I say, yeah, that looks fine. Well, the neighbor is going to say, well, you made me plant 2 holly bushes and 1 arborvitae. How come that was allowed? So
Yeah, no,
gets a little bit in the way.
that makes sense. I guess what I'm trying to avoid is a situation where you have a neighborhood and the vast majority of the houses have additions or are built up to the roof line, right? Have the additions over the garage, whatnot, up to the roof line. And then just because one house, just because the way it's set and where those setbacks are, and maybe it's conforming and the others aren't, et cetera, like that's the only house that can't basically build a house that looks like every other house in the neighborhood. That just strikes me as not okay. And I don't know. I'm trying to figure out a way where we can avoid those situations, which don't make sense. Well,
Yeah, I don't think you're ever gonna avoid that completely. There's always going to be some sort of outlier, or there's always going to be some percentage of properties and homes and houses that are, I'm sorry, you don't fall into this category, so you can't do this. What that number is, I don't know. Again, I would venture to think that at least 2/3, maybe 3/4 of the house or the lots in Westwood are non-conforming. I would think that probably, especially in the Maze, Islington, general residence, SRA, SRD, there's probably 50% of the houses are non-conforming due to different things. But there are houses in the 2-acre zones that we have in town that are non-conforming. And it just happens to be because the house is, 200 years old and they subdivided their land 150 years ago and bequeathed some of it to their kids. And they said, you know what, we're just going to put our house right on the property line. So, there's if thens and there's different things in circumstance throughout town. There's not a one size fits all.
let me ask you one more question before I turn it over. But your interpretation of the bylaw, was that based in any way on how you felt that it would aesthetically impact the neighborhoods? Was your interpretation based on your perceived aesthetic impacts
No.
on one interpretation versus the other, or is it just the pure language? This is how you read the language. It's not really about how you see that.
I am, and Nora will attest to this during different, FS1 committees and different things. I'm the king of function over form. I do not care what anything looks like. If it works, it works. If it doesn't, it doesn't. So if you build a monstrosity like Boston City Hall and it looks ugly as hell, but you've got the square footage that you need in there, then so be it. That's what it is. I really do not get into the clapboard versus stone versus shingle siding, things like that.
Just personally, do you think there would be an impact if we went back to the average height? Do you think that could result in an impact on how the neighborhoods will look, 10, 20 years from now?
Yeah, I think you would get, I mean, whether or not it's negative or not, I don't know. That's not for me to say, but I think you would have the vast majority of houses, let's just say in the maze, Islington, where maybe the vast majority of houses would be, 10 feet off the property line.
Mhm.
For good or bad. That's less than a driveway. So if that's what the bylaw says, that's what the bylaw says. If it's not, it's not.
You're just saying because the existing house will go over into the 5 foot buffer that we have now, so there would only be 10 feet.
Yeah, or people would say, you know what, I can get over to that 10-foot line with a 2-car garage. I'm gonna tear down the house that's on the property. I'm gonna build a 2-car attached garage. It's only going to have an average height of 15 feet, but I'm going to have a 2.5-story house on the other side.
Thank you.
Does that help? Thank you. I saw Nora and then I think Phil and then Maureen.
So I just wanted to point out again that the bylaw has setbacks that are determined. The setbacks in C and E are 20 feet on the side. The setbacks in A, B, D, and general, I believe, are 15 feet on the sides. The provision that was put in place in the early 60s to allow you to shrink those setbacks, to shrink the 20 to 15 or to shrink the 15 to 10, was predicated on the portion of the building that goes within that setback being no higher than 15 feet, absolute height of 15 feet. That's how it was originally intended. If there's a different intention now, I think Mike had suggested change the setbacks. If you don't want it to be a 20-foot setback, make it a 15-foot setback and then average height applies and get rid of the footnote entirely. If you don't want it to be a 15-foot setback in the A, B, D and general residence zones, make it a 10-foot setback and just say what it is that you're actually trying to achieve. I think the clearer this is, the better. We have a bylaw already convoluted, and adding more language that makes it more convoluted, I don't think is really helpful. So if we want to allow full height buildings within the setback areas, then let's just reduce the setbacks and eliminate that provision altogether.
Thank you. I think Phil, I think you were next and then Maureen.
I guess I take a little bit of a different approach, which is a little bit more, without quoting the Hippocratic Oath, I'm going to do so, do no harm. This is far more than just a clarity issue. This is an impact issue, and the impact on the level of and the depth of what I think needs to be considered is not before us at the moment. And in some respects, I'm coming around to the point that it may make more sense to shelve it, leaving flexibility, leaving the place whole, the existing provision in place for a more in-depth discussion, because there are impacts here that I don't know that we have fully delved into, and I think we should, because they're just some of the process that has now come out gives heightened obligation, I think, on each member of the board, and I feel it myself, to consider, how we should not go into a town meeting without being able to advocate for this. Whatever the vote is, we as a board should be advocates for what we are doing. And I now have a question in my mind as to whether or not I could be an advocate. So that's just my point. I think we need a more in-depth consideration as compared to something that was I was considering it for clarity, but now I consider it to be far more complicated. So those are my points.
Thank you, Phil. Maureen, you've been waiting very patiently. Thank you.
You're welcome. I agree with what Phil said. I think we, as a group, need to do more work on this. I need more clarification on some of these things myself also. Some of the topography that we're looking at for some of the homes, is that making it too restrictive for those people? The non-conforming lots, does that make it more, easier for them to do something? I think there's a few things that we need to kind of look at before I feel that I could make a decision about this. Right now, I don't think this is the way I would like to go.
Thank you.
Yeah.
Okay. I appreciate the time and care on this because this one I think for me is one of the bigger ones. Yes, Mike Perkins.
No, I was just gonna. Oh, am I on mute? No.
No, we
I'm sorry. I was just gonna say if there's an appetite to um, address inequities, real, perceived, or otherwise, and address the greater picture of what the future of the town of Westwood is, as far as allowing expansion of existing homes or construction of new homes, or not. I would just ask that if the board has any questions or things that they would like to pursue or try to gain more knowledge on, that you would ask myself, Nora, Amanda, staff to provide some sort of answers or clarification on things. Because I mean, if we're talking about a whole hog, not revisitation of the entirety of the zoning bylaw, but if we're talking about, hey, we want to allow more expansion, more construction, things like that, is it really looking at all the dimensional requirements and things in the bylaw that, for lack of a better term, restrict building expansion and modification of existing homes?
Yeah, no, thank you. I think that's a good point. And I think we touched on this before 10 or so years ago when the conversations about setbacks came up in the smaller neighborhoods, particularly the Mays, the School Street, Islington neighborhoods. The general consensus that I was hearing at meetings, again, just attending them, was that people wanted more restriction. That may have changed, but that's a bigger conversation. So I agree if that's a bigger undertaking and it's not just setbacks. I think that there's more to that picture. So I appreciate that point, but I'm kind of landing where it sounds like my colleagues are, is I understand the ask, but I'm just really I'm having a hard time, especially with the fact that if the same existing house were 5 feet to the left or 5 feet to the right, they would have the flexibility to potentially, via special permit process, do more than the house that's actually conforming to the setback. So that's a tough one for me. It's almost like it's punitive to the house that's conforming to the setback, whereas there's a house behind me, on a street behind me that literally looks like it's like 4 feet off the property line. Like they could shake hands through the window, and they were able to do things that maybe the neighbor on the other side couldn't. So I'm sensitive to that. And given that we've gotten a lot of feedback from people in those neighborhoods who would be most affected. And again, thank you, because I know we were hearing from a couple of people, but we did receive over 100 signatures. So I that speaks to me that there are people who are not happy about this potential codifying of a hard and fast 15-foot cap. So I have to listen to that, particularly if, again, like the house next door to a person who happens to have a conforming setback could do one thing and they can't. So I'm having a hard time with that. Mike, I saw your hand up.
Oh, and so I was curious, how long was the prior building commissioner's interpretation in effect for?
Um,
And yeah.
22 years, I believe he was in place. Joe was before
Okay.
me.
And we think before that it was the interpretation that we have now.
so
Um,
for 43 years, it was clearly the interpretation we have now because there was no definition of average height. The prior building commissioner asked the planning board to put in the definition of average height for building height in 2004. So from 1961 until 2004, it was the interpretation that we have today because there was no average building height. From 2004, when that definition of average building height came into play, till sometime after that, I believe the interpretation was the same. I think it was sometime after 2004 that the former building commissioner changed his interpretation. I don't believe it was when that average building height definition was first put in. I think it was
Yeah.
more recent than that.
Okay, so there's been 20, there was a significant amount of time with the prior interpretation. So theoretically, when you walk around these neighborhoods, you should, I mean, be able to see a lot of examples of buildings built under that interpretation, right? I'd be curious to explore, what are those houses? What do they look like? Do I perceive that this is, negatively impacts the community? Or do I want to promote that type of building? I don't know right now. And so I think I agree with Phil and everyone else that I don't have a clear answer. So I wouldn't want to move one way or the other on this.
I have one more
Mike, there's some
question.
pictures in the package from the community that show some of the examples. And Mike, keep me honest, but I don't know if some of these examples were constructed during that prior interpretation. Is that the right way of thinking about these? If Mike Derderian is looking for examples,
Yes, I
I don't know
think
if Mike
there are
Perkins-
examples that were constructed within the last maybe 12 years or so that
Yeah,
were interpreted by the former building commissioner as applicable to average height.
I just didn't know the timing of when those happened. I assumed it happened during that interpretation.
And I actually had a question about one particular property because it's kind of being held up as an example of like where the addition is actually taller than part of the rebuild. And I'm curious if that happened under this particular part of the bylaw or whether that was an existing nonconformity or how this came to be. So I don't know, Mike Perkins, do you currently have the ability to kind of check on this particular property if I give you an address, or is that something you'd need to
I can
access?
I can try and pull it up. What address are we speaking of?
194 School Street. Like looking at Google Maps, that looks
Yeah.
like the existing house was already 10 feet from the property line. So I don't know whether that was an existing nonconformity or not, but I'm
Yep.
curious. Thank
Hold
you.
on. Let me bear with me for a moment here.
Yeah, no, I kind of sprung it on you, so I appreciate you. I wasn't sure if you could look it up kind of on the fly or not, but I was curious since that one has kind of been cited as like well, the addition is taller than the main part of
I
the
think
house.
most of the garage and above it was not there. Ellen, I
Yeah.
live on the street.
Okay. And even looking at the older pictures on Google Earth or whatever, it was a cape that's now a colonial with a very tall garage and addition over it. So I'm actually not sure how the whole thing kind of came to be, whether it
Yeah.
was a
So the right side of the house, if you're looking at it from School Street,
Yes.
is almost 19 feet off of the property line.
Okay.
So that portion of the house um, meets a setback requirement of 15 feet. So they can go up to an average height of 25 feet. And if they wanted to, they could have extended that over another 3.8 feet. And again, depending on whether or not we're talking about average height or absolute height, would be the difference between, let's just call it, an attached garage being 10 feet off the lot line or something that's 2.5 stories right there off the lot line. So yeah, that house, I'm looking at the plot plan right now, is 25.3 feet from the front lot line and 18.8 feet off of the right side. That one is a particularly I don't want to say small lot, but it is square, is 100 feet, basically 100 by 90. So it's a small lot. Even in that neighborhood, it is a small lot.
Does that lend credence to the argument that people will build higher versus extend outward slightly?
Well, we still have, there is still the absolute, or not absolute, there is the restriction of average height being 25 feet.
And yeah. How many houses in this neighborhood do you think are at that 25 feet? Do you think
in the School Street, Ridgewood type area, half probably.
So we would prefer people to extend off the roof line versus going up to 25. I mean, it depends what your preference is, obviously is, but
right. It depends on if you want your, again, like Ellen was saying, the complaint that we've heard in the past is always, how come this guy's house is 10 feet from the property line, he's looking in my bedroom window? Or is it, hey, they're way too close to the front lot line, there's no front yard, they're right there. Or, and again, it just pick your poison. Do you want them to get closer to the lot line? Do they want them to go higher?
But to be clear with that house was done by right. There was nothing.
Correct.
Okay.
Correct. There was no zoning relief required. No.
Gotcha. So they were well within their setbacks. They went up to the 25 feet or close to it or whatever. That's not affected by any of that. They could do this regardless of what any
You could have done it.
There's no interpretation. It's
right. You could have done it 20 years ago. You could do it tomorrow.
Got it. Okay. That's what I was trying to figure out, because I know that house was kind of being looked at, and not to pick on that house, but is this something that could happen within if we leave this footnote as is, but that house had nothing to do with any of this.
Correct. And again, we go back to, like I was just saying, do you want to go up or do you want to allow out? Right. If you allow out, then, not to get too much into the details of everything, but now you're talking about more impervious area. So you're talking about more stormwater considerations. Do we want to go for FAR, floor area ratio, where you talk about if you've got a 10,000 square foot lot, you can only do 25% of that as living area.
Right.
Now you're limiting, no matter what, either up or out, the size of a house that can be placed on a property. I don't know if that's something anybody wants to tackle.
And the impervious surface, I mean, that's regardless, right? The impervious surface part of the bylaws. So if someone increases their impervious surface, whether it's through an addition or whatever, they're going to have to mitigate that with runoff control, right?
Right. But but what I was trying to say is if you go up above the existing footprint, you don't have to do that.
Right. That's more for the property owner, right? So whether they want to end up spending more on more drainage rather than just going up and keeping their impervious surface.
Yeah, and it depends again whether or not the Conservation Commission would, say, okay, you've got to do X, Y, and Z for drainage and do plantings, landscaping, things of that nature. It depends on what you would want to do as a homeowner.
Understood. Yeah. Thank you.
My sense is, and Alan, this goes back to what you said maybe a while ago, but I mean, I would be okay, from a policy perspective, using the average height, but capping it at the roof line. And it sounded like that could be a compromise. So I'll throw that out there.
So I guess the question I would have then is, would it be to the existing roof line of the house, or would it be the existing or the roof line that could be constructed by right? Because then you get into, well, this part of the house I can extend up.
Existing.
And I match that.
Existing.
It would be the existing.
Yeah.
At least even as a placeholder until we take a more in-depth look at all these different factors that we're talking about. But I certainly don't want to penalize people for building up to their roof line right now. So
I would take a much different attack, which is I don't think that we should be making what are clearly material changes unless we know what we're doing. I want to be an advocate for anything this board votes for. Right now, I feel very much more than I did previously. And in many respects, I feel, that from my own perspective, I feel too much by the seat of my pants to be able to say the impact of what we are doing is appropriate for the town. I want to be able to stand up at town meeting and be an advocate. I don't feel that we can, at least for me, I don't feel that I could do that. And I say we need a more reasoned and in-depth consideration as to what we are doing and the impact on differing neighborhoods. The maze of Islington is far different than other different parts of the town, and we need to know what we're doing before we start, codifying something that we don't know exactly what's going to be the impact. And that's a real. So yes, it is. Is it the best of all possible worlds? No, but raising the issue and saying you as a planning board need to know how to dive into this issue is important to us. And it does not make sense where we are at this stage to try to get this by a seat of our pants for a town meeting this spring.
Yeah, I guess, Phil, if I were just to play devil's advocate, and I don't disagree with a lot of what you're saying, but devil's advocate, I would say, well, we had a prior interpretation for almost 2 decades. So
Yeah.
we know the world's not going to fall apart. In especially this interpretation would cap it at the roof line, so would be getting rid of the worst case scenarios of this interpretation.
But codifying is far different than an interpretation by the building commissioner. That is much different, and an advocacy by the town, which as a legislature, the town meeting, then endorses or does not. And it might also impact if we do not get it passed, whether or not we come back the following year with something more reasoned. How do we go in front of a town, meeting and saying, okay, let's codify this, but we don't know exactly what the impact is. So
This is a lot to consider, but thank you. All good points. Any other board comments at this point, or I would like to open it up to public comment. Also, again, for transparency, we have 6 people in attendance, in addition to the 10 people you see on your screen. I'm not exactly sure that it's the same 6 people, but there are 6 people in attendance. Are we good with opening it up to public participation at this time? And then if board members want to discuss more, we can loop back to that.
I think the
Um,
public should chime in.
Thank you. All right, I do see a hand up. We will start with, we have Ryan Chipman, if we can promote him to speak. Mr. Chipman, we'll just need your full name and address for the record.
Hello, Ryan Chipman from 81 Cobley Street. Thank you to the board for having me back again and for the continued lively discussion on the topic. Whatever other more extensive amendments the board might consider in the future, I want to emphasize that citizens need relief from this board, or need this board to provide relief from the current unreasonable restrictions at town meeting 2026. As interpreted by the commissioner, doing nothing allows the 15-foot absolute height standard to stand. That is how it's being enforced right now. A zoning board appeal is almost certainly going to be denied at the hearing tomorrow. So a pocket veto via postponement here is effectively the same for residents as officially codifying the absolute height in the bylaw. And as Nora, Tim, others have noted, sorry, not Nora, Ellen, Tim, others have noted, the 15-foot absolute height standard is unreasonably punitive to Islington or other small neighborhoods. And I'm here with the written support of over 100 other residents of this neighborhood asking the board to restore residents' rights that they enjoyed for over 20 years under Commissioner Joe Doyle by codifying the average height interpretation and rejecting these new restrictions. At the last hearing on January 20th, the board asked for 2 kinds of evidence to inform and support the decision. To know what the community actually wants, specifically from the people who actually live in these most affected neighborhoods with small lots, and for pictures showing real examples of what has actually been built in the past under the average height rule. And we've provided both of those pieces of data to the board. They're included in your meeting packets. One of those attachments is the petition, and that petition asks the board to reject the commissioner's new restrictions and to codify the long-standing average height measurement method. Over 100 residents signed that petition, and again, not any 100 residents, but 100 residents who live near us in Islington on the small lots impacted by the bylaw. And the community isn't asking the board for protection from their neighbors' additions. They're asking the board for protection from unwanted and harmful zoning restrictions. The community has spoken clearly here, and the board has an obligation to listen. In too many instances across the town recently, boards have seriously damaged the fabric of our community's trust by ignoring the community's clearly expressed preferences. And I hope the board will listen to the voice of the community here. We've also attached multiple examples of both proposed and completed projects that are subject to this point of bylaw. These projects are all conforming under historical average height interpretation, but non-conforming under the commissioner's new restrictions. And these projects are all modest additions that preserve the character of the original house and of the neighborhood. These are the kinds of additions we want people to be doing, because if we instead push them to knock down or expand vertically or just retreat inside the setbacks to avoid these restrictions, they build much larger structures that have far more visual mass. And the board has discussed the kind of example of one such boxy knockdown that I included in my packet, which was built by a developer a couple of years back at 194 School Street. As Mike Perkins noted, this knockdown is entirely within the 15-foot setbacks, but this home is far less in keeping with the neighborhood character than the examples that were built under the average height rule. And as Mike Durdurian raised earlier, the relevance of this example is that it demonstrates why it is better for neighborhood character for people to make small side additions to existing capes than for people to undertake large vertical expansion within the 15-foot setbacks. At the last hearing, the board also requested specific examples of what projects were approved under previous Commissioner Joe Doyle that our current commissioner considers to be so objectionable. And the commissioner didn't provide any such examples, only hypotheticals. But the reality, which you can see in the real world examples that we've provided, is that none of these projects being built under this average height side setback affordance are objectionable. Nobody's building a Swiss chalet. They are meeting their family's needs via modest side expansions that are harmonious with existing structures and with the neighborhood. In summary, the key facts are as follows. Fact 1, the commissioner's new rule is a significant change. For over 20 years under the previous building commissioner, Westwood residents exercised their right to build additions that make use of the average height rule in this 10 to 15 foot side setback zone. The commissioner's new restrictions abridge that right, and residents are actively suffering harm as a result. Fact 2, there is already a huge problem with housing affordability, which is exacerbated by these new restrictions. Between interest rate changes and the housing market, moving to a bigger lot is simply not financially feasible in most cases. Limiting addition options even further leaves families with no good path forward for accommodating growing needs within reasonable budgets. I think, Phil, you mentioned earlier how even though some lots might be able to expand backwards or expand in different directions, we know firsthand from exploring our own project that adding second story space by changing an existing roof line is incredibly expensive versus simply extending a roof line by, say, adding above a garage. It changes the feasibility of a project entirely. Fact 3, this change disproportionately impacts Westwood's most affordable neighborhoods. If you're on a larger lot, this rule generally isn't going to make any difference to you. You're not constrained for space. But if you're in our smallest neighborhoods, with even smaller non-conforming lots, like our neighborhood in Islington, these new restrictions can make or break an addition being affordable or feasible at all. This affects whether people can stay in their community, and that matters. Finally, and most importantly, the residents who are impacted by this change do not want more restrictions, and they want you and have asked you with their signatures. They put their names on the lines to ask you to codify the average height method. The ultimate ground truth that this board needs to return to is the clearly expressed wishes of the community. And for these reasons, I implore the board to bring clarity to the bylaw by codifying the existing and historical under Joe Doyle average height interpretation, or if the board prefers, maybe Ellen and Mike's proposed extension of the existing roofline standard, though I think the most minimal change possible that would provide residents with the relief they need would be to simply clarify that average height shall be used. Whatever other more extensive amendments the board might consider in the future, the board does need to provide immediate targeted relief for the unreasonable restrictions currently being imposed on residents and the harm that those are causing. Protecting residents and enabling us to stay in our homes by restoring our right to reasonable, affordable additions that we had and exercised for 20 years is quite simply the right thing to do. Thank you.
Thank you, Ryan.
Is Ryan able to still stay? I actually have a couple of questions.
I can re-enable it. Whoops, hold on.
We do have a couple of other people, but yes, Phil, I think.
Yeah, just a
questions.
couple of questions.
Okay, there you go.
Ryan, can I just ask you a couple of questions? Because obviously you've heard the tenor of my questions, but what degree have you say the community, but the community is not just Islington, it's also the Maze, which I'm very sensitive to. It's also other neighborhoods. Codification of unintended consequences. And I hear you, and obviously I'm expressing sympathy towards the Islington residents, but what's your view, if you have one or even know of one, the impact on the Maze or the impact on other districts and other areas in Westwood.
Yes, absolutely. So I can speak to that. So we believe that this is fundamentally a kind of community impact, which is why we stayed in our own community. We didn't go like canvassing at Roach Brothers or putting online petitions.
Mhm.
We just walked around and talked to our neighbors who we saw while we were walking the dog or out shoveling driveways. But I think that the proposal that our petition asks for and that we are exhorting the board to consider here of codifying the average height interpretation that Joe Doyle consistently applied over his 20-year tenure is, I think, exempt from some of the same concerns that you have about unintended consequences of bylaw changes, because unlike other potential changes, this change was in effect for 20 years. And if there were terrible outcomes that were arising as a result of this bylaw, we had 20 years to see those arise. And in reality, the only examples of projects built under this point of bylaw that anyone has brought forth to the board here are the ones that I have shown, which I hope the board would agree are eminently unobjectionable. And that's
Well,
why I fully agree with you, Phil, that like the more ambitious changes, anything that we haven't done or seen before, yes, the board should take its time. But
well,
the board should also not pocket veto the restoration of the right
it's
that
not
we
a pocket veto, but you would probably agree. Obviously, the existing building commissioner should be a voice of how and a voice that we should consider. And my concern is you still have options. You may say ZBA is a dead end or something else, but I my concern is not and obviously I'm expressing a great deal of sympathy, but it is also, if we are doing something to codify something, it is got to be codified with an impact and an understanding as to what we're doing, because that's something this board I take extraordinarily seriously, and I am extremely sympathetic to your position and your submission, but we have to know that we can advocate to the entire town what is being done. Would you not agree with that?
I would. I would also say to the board that there is no abstention or deferral of the question here, because the ZBA is a dead end. And to anyone who doubts that, I'd encourage you to go watch the ZBA hearing that we had last month, or attend the one tomorrow night if you'd like to see. The ZBA's clearly stated position, Mike's clearly stated position, town council's clearly stated position is that the commissioner's absolute height interpretation stands. So there is no like, the board is making a decision either way. To not act on this is to leave Westwood residents subject to the 15-foot absolute height restriction.
No, I utterly disagree with that. I think of what it does is saying is the board is giving a reasoned consideration to the information being submitted, and a reasoned consideration as it impacts not just Islington, but other communities. And I say that with evaluating and giving great consideration to yours. But before we make a codification, that is a substantial step for the town, for its consideration. We need to make sure that we know what we're doing and we're appropriate advocates for that. Would you not say that's correct?
I would say that it's no worse than what happened when Mike Perkins took over from Joe Doyle in 2023 and started enforcing a new standard. And in fact, in that case, that change in interpretation, that new restriction, was imposed without any voice of the residents. And now the voice of residents is being expressed, and there are 100 residents asking you to restore the rights that we had.
There is always interpretation because we delegate authority to the building commissioner. We have trust in the people that are staff. The staff informs the board. However, you are asking for a codification of something that from my perspective, and you've gotten my open ears, absolutely. But the codification to go into town meeting to a differing position is a significant step. I just want to make sure that you take a broader view than just the Islington view. And I'm sympathetic, especially as it impacts the maze and others. So
yeah, indeed. And in the maze, there's actually a contemporaneous example of
I'm
38
well aware.
38 Body Street in the maze is a building permit application was just submitted, is going to be approved by Mike Perkins shortly, is subject to this exact point of bylaw is 22 feet, I believe, at the peak within this 10 to 15 foot zone, is only allowed under the average height rule. That project is about to be approved, and it approved with the enthusiastic approval of Town Council Pat Ahern's wife. They're the next door abutters as a recent example from the maze.
Oh, well, I'll take exception to that point, but I think the impact on other small neighborhoods such as the maze, the impact on others out throughout the community, that's something that I think has to have more evaluation. I said my piece. I'll be quiet.
Phil, I'm curious, Phil, what did you imagine like this body of evidence or analysis, or is there like would there be like an impact analysis someone would do on different neighborhoods and what the aesthetics would how that would change? I'm just curious how do you envision what we would do in the next 12 months?
I think the impact of this is clearly concentrated in certain areas, and I'd like to know, as compared to a seat of the pants, what's the non-conforming as compared to conforming? What are we actually talking about as compared to how this is going to impact if we put this forward to the town? And I don't feel I've had enough information to be able to say that.
Did you have another question for Phil, Mike? Or I know Maureen's got her hand up. She's
No, I don't. Phil, you did mention, should we give consideration of what the building commissioner is saying? But I just want to point out when I asked the building commissioner, was he making any type of policy or aesthetic or statement on what he perceived the impacts to be, that he wasn't. It's just literally how he reads the words on the page, right? And so to the extent we give deference to, when these original words were passed, yes, that's one thing. But I don't think the building commissioner's interpretation has any bearing on what perceived negative or positive impacts that he sees from this, which is what you're talking about. So I don't think
that's absolutely not what I'm talking about. I think what I'm saying is we rely upon the staff, whether it's Nora, Amanda, Mike, or others, to consider what is the written word and to interpret it appropriately. If we're changing the written word, we should do that in a reasoned way. That's what my point is. I rely upon Mike Perkins just as much as everybody else, and I think he's doing a great job. I rely upon Nora, I rely upon Amanda. And that's the point that I say. Before we impact the written word, I think we should have an understanding as to what we're doing.
Thank you both. I'd like to go to Maureen. She's been, again, waiting very patiently.
I just have one point of clarification. So on our books right now, we have got the average height is what we have, correct? As our bylaw, building height, the two drawings.
So we have the drawings and the definition of average height. And
Yep.
then we have footnotes that refer to the height of a
5 and
portion
7.
of a building, which
Yep.
is not interpreted to count as average height.
Okay.
We have a dichotomy in the bylaw.
Yeah, I saw those two. It was 5 and 7 were the two that went with this. And what Mike has done here, he's further developed that picture to show what he interprets 5 and 7 to be to a property, correct?
Correct.
Okay. So 5, and this is not yet in the bylaw. Or
No, this is offered as an amendment to the
amendment.
bylaw
Okay.
for the purpose of clarifying the way the bylaw is currently interpreted and the way it was interpreted before there was an average height definition in the bylaw.
Thank you.
Thank you. Mike Perkins and then Tim. And then we have someone else waiting to give public comment.
Yeah, so I was just going to say, Maureen, the way that the zoning bylaw is worded right now, those two notes, 5 and 7, make reference to the portion of the building's height. The average height definition applies to, in my interpretation, the height of the building. So when you're talking about that portion of the building height, it's the actual measurement. And so that's what this proposed amendment is clarifying that is what the interpretation of the bylaw is.
And can I just ask you one question? And I don't know whether you can even answer this because I saw a picture. can I even ask this question? The Chipman's house, and I saw the photos as we did that were on, line.
Mhm.
And can you say what they went to the Board of Appeals for?
There was no
Until a
building
decision
permit
is made.
application. Say that again. I'm sorry.
Or you can't right now until a decision is made.
No, you can discuss the app.
I
Okay.
can
I just
can
want to
talk
know
about
what about their home did not fit. I guess
So if you looked at, I don't have it right in front of me, but it was it was basically removing the existing one-car garage, bumping it over a little bit, and then building on top of it with another story, extending the existing roof line, second floor portion of the house over that garage. And because there was a section in that intervening 5-foot space between the 15 and the 10-foot lot line, or setback line, I'm sorry, that was over that 15-foot absolute height. I had noted that that would not be allowed. It would be a variance. And so, okay, yeah, here it is on the screen. So essentially, on the left is the proposed, or yeah, the proposed addition would be. On the right is what I'm saying in my interpretation. The bylaw allows that little section, that 5-foot section on the right side of the garage, would not be able to match the rest of the roof line on that addition.
I'll show the side view too, because I think it's helpful.
Yeah, so the one on the left side would be with the absolute 15-foot height measurement. Again, put the stick on the ground and measure up 15 feet, as opposed to averaging the height from the highest point of grade adjacent to the house. So again, that's the other thing that comes into play with the average height measurement, is it's not necessarily at the point where that portion of the structure is, it's at the high point of grade on the property. So if you live on a hill, if your property is on a hill, you measure at the high point, not the low point.
Thank you.
Thank you. Tim, and then we'll go to, there's a person waiting to share some public comment, but Tim, we'll go to you first.
Yeah, Phil, sorry, I just want to push back a little bit on, I feel like understanding what we're going to get out of this. There is there's essentially 2 decades of precedent of what we're going to get out of it, right? Because the interpretation, whether it's codified or not, is the resulting additions that have taken place during that time period. It is what would come out of it. So I guess I'm all in favor of doing more diligence where we can, but we do have a pretty strong body of evidence from a long track record of what what some of the outcomes would look like. So just pointing that out. And I guess the one other thing I would want to say or ask is, is anyone in the community or online or participants who are strongly opposed to the average height interpretation versus the flat height? Because I think I really want to do our best to listen to the community, and I didn't see any materials submitted, and I would just be curious if there's anyone who feels strongly in the community who's the whole point of this was to kind of hear both sides, and I respect hearing from Mike, and I value that, but also members of the community, if there are folks who have a strong opinion in the opposing direction of what Mr. Chipman's putting out there. Just want to throw that out there, make sure we're covering our bases if that's the case.
Yeah, thank you. I think that's a good point, because, as excuse me, as we said, the sentiment was very different 10 years ago, but that's also 10 years ago. But so far I haven't had any outreach on, contra to the ask from what we're hearing. But and I hope we've, we've advertised this and asked for feedback, and I haven't heard anything yet so far. Excuse me. I haven't seen anything submitted, but it is a good point to ask that again, if there's any active opposition to what's being requested by the constituents. Mike, I'd like to go to, there's someone that's been waiting for public comment, unless this is
So
something.
I just in 5 seconds, I think like one of the big problems that stands out for me, and I think the Chipmans is sort of an example, is like this rule applies, this 15-foot rule applies, even if the house next to you is 25 feet tall, right? Versus a small cape. So again, it seems very arbitrary to me in terms of, and I know you have to have hard and fast rules, but if you have 25-foot houses on each side, building that 15-foot addition into the 5-foot buffer, like it's going to make no impact on how that street looks. So I just thought I'd add that, but thank you.
Thank you. I'd like to go to, I'm not sure if I'm pronouncing your last name correctly, but Bobby Nason or Nason. I apologize if I got it wrong, but can we promote Bobby to speak?
Thank you, Ellen. It's nascent, so you got it correct, really,
Thank you.
which is impressive because that usually doesn't happen that often. So, good evening, everyone. My name is Bobby Nason. I live at 87 Cobley Street. I'll be very brief. I know this discussion has gone on for a while, but I'm a neighbor of Ryan and his family, and I'd like to echo and support what Ryan just said. My family has lived in the Islington neighborhood for 6 years now and truly value the relationships we have with all our neighbors. As you know, and I know this has been discussed a great deal over the past hour, Islington is a tight-knit community. Houses are pretty modest overall, and space can be at times challenging for growing families. I know it has been for mine. I believe that what the Chipmans are proposing is reasonable, and I hope that this committee will consider their request, not only for them, but for other families in this neighborhood who in the future want to add to their homes and stay in the community. Thanks for your time.
Thank you very much. Yeah, I mean, I think I already said it, that when we talk about allowing people to stay where they are, I think we've typically talked about that in terms of aging in place. But I'm becoming more and more aware of and sensitive to that also applies to growing families. So I do think there's a lot more to discuss here, but Phil, I'm really sensitive to what you said, and I agree that there's probably a bigger conversation here, but for the immediate issue, if we do nothing, things continue on as they are. And I am hearing that there is a concern about that. That's why I was asking, like, is there a way that we could, within the neighborhoods that we've talked about being the most effective, maybe say like, no higher than the existing roof line adjacent to where they're looking to expand. I don't know if there's a taste for that within the board, but I think that might provide the relief that people are asking for without allowing too much, and only in the neighborhoods, in the zoning areas that it makes sense to do that. But I see Nora's hand up, so I'm going to stop talking and ask Nora to weigh in.
I just want to comment that whenever you refer to an existing building, the building can be changed. The building is not stagnant. So you could have a case where there's a building that has an average height of 15 feet for the overall home. They want to put an addition on that has the higher level within the setback. They can build the main portion of the building that's not within the setback to the maximum height. So it by putting that limitation into the footnote, you're not limiting the height of the building to anything less than a 15-foot average height. So if you're interested in allowing up to 15-foot average height, that's still less than the 25-foot average height that's allowed outside of the setbacks. So you're still would end up with a shorter building in the setbacks than could be achieved outside of the setbacks on the conforming portion of the lot if you simply change the footnotes to read average height instead of the height of the portion of the structure. So you can do that, but you will see larger structures within the setbacks. Not as large as the maximum height you could have in the center of the lot, but larger than what you would have now. So I think what's important is that you're taking whatever you decide. If you are bringing an article, as Phil said, if you're bringing an article and the board is 100% behind it and ready to recommend it to town meeting, you need to be able to explain to town meeting what it is you're changing. In 2004, when an average building height definition was brought to town meeting voters, this was not discussed. No voter who was voting on the average building height was directed to see how it would apply to the portion of a building in a setback. That definition was described as for the conforming portion of the building, and that's all it was described for. So if you want to do something different than that, I think it's just very important that all voters understand exactly what it is that's being proposed and what the potential effects would be. I'm not saying the effects are good or bad, but you need to be clear in that. And so I think if the board is of one mind on what you should go forward with, and you're ready to defend it to voters and try and achieve a 2/3 outcome at town meeting, then go right for that, and we can draft it so that you have the average height apply within the setbacks instead of the height of the portion of the building. We can draft it either way, whichever way you think is appropriate, but I would caution against tying anything to the height of an existing portion of a building because that can very easily change.
Thank you. That's helpful advice. And you've also just reminded me of another really important point is, so whatever we propose, it still has to go to town meeting. We need a 2/3 vote, whether we change it one way or another way or not. Well, if we change it to either hard stop at 15 feet or codify average height, either way, it still needs to pass 2/3 threshold. And if whatever we try to do fails, it just stays exactly as is, correct?
Correct.
Okay. So I think that's important to have as part of this conversation, that we can propose and defend whatever we decide to propose and defend. It's still going to be up to the voters at town meeting. If there's opposition that we're not hearing now, I'm certain we will hear it at town meeting. So it still needs a 2/3 threshold. And if whatever we propose doesn't pass, the bylaw stays as it is today.
It's not just that, it impacts the next town meeting by a vote that is, whatever the vote may be, impacts what happens for the future vote. So if it did not pass, or it is hard to tap the well twice when you go to town meeting. And if we go to town meeting and we do not get the vote, then I don't want to say that it has longer unintended consequences. So
It's a bit of a conundrum because I'm hearing a request for relief, but I'm also I understand your concern. I know exactly what you're saying. So I'll leave it at that for now. I think we have to figure out what we think is the right thing to do now.
I was going to ask Nora, was your comment that like the existing roof line could change because you could do multiple additions, right? So you could raise that and then you could do was that essentially the situation you were envisioning?
Yeah, you could do it in steps, but you could also just propose a new building where the new building has the conforming portion of the building at an average height of 25 feet. And then you have the part within the setbacks.
What you're saying is it's a little more complicated because there's a number of ways people could get around I think we all know what we're trying to say here, but there's a number of ways depending on the steps and what they're actually doing where it could be impacted. That's the point.
And for that reason, the clearest direction is always the best. If you can say in as few words as possible and have an absolute clear direction, so whether that clarity is through absolute height of 15 feet or through average height of 15 feet, just a clear statement that everyone reads the same way. That is always the best way to go. But I can't tell you which one is the best way.
Yeah, well, but I mean, I think you could have multiple provisions say in this situation. You could probably describe it. It's a little more complex, but you could tie it to the existing roof line, as 2 years before the project started or something like that, but it's more complicated is what your point is.
If you do that, then you get into a question of equity again. I think that you would say very much like you have a non-conforming structure and you can do more than someone with a conforming structure. If you have a higher height, you can do more than someone with a lower height. So I think tying height of an addition to the height of an existing structure is a very slippery slope.
Well, and this is, I mean, I think the current rule is penalizing people who can't knock down the house and build a completely new main structure, right? Like that's the point, right? It's the additions probably over the garage into the setback, that type of thing, where they're not going to raise the height of their main structure. So the whole thing is bothersome to me. I don't like, it does irk me, which I think we've all expressed.
But you're also saying the ZBA process is a nullity, and it may be one where, and I don't discount Mr. Chipman's concerns, but there is a process at the moment. Whether it's a process that has a high degree of consistency, which may not be what certain, the way certain residents and certain applications go, but there is an option at the moment for a reasoned consideration as to how we take what kind of
I think
appropriate.
the ZBA in Ryan's case is just purely are they confirming or are they going against the building commissioner's interpretation, right? That's all they're probably ruling on in terms of that part of the application, right? Ryan's asked them to interpret it differently, and so are they going to overrule the building interpreter commissioner or not? Like that's what they're looking at for this issue.
Right.
They're not
But
making
then,
it. I would prefer that they made a discretion judgment, right? If you're sitting between two houses that are both 25 feet, yeah, probably doing the actual height isn't going to impact anything, right?
but then the planning board is making a reasoned decision to overrule Mike currently to go with a prior decision if that's the way the board chooses. So we're saying the prior building commissioner's approach for a long period of time. And there's obviously lots of different changes that have occurred in Westwood from 61 to 2002 or whatever it was, then the succeeding 22 years, and then the last 3 or 4 years or whatever it is. There are eras and impacts. But I don't know
Yeah.
that we're prepared to be doing that.
I guess I'm still cloudy on the impacts, right? In terms of the impacts are going to be what Ryan described. And you can build buildings higher. That's going to have these pros. What are the negatives? Well, the houses are going to be built higher. The building commissioner can tell you that. He said it an hour ago, right? You're going to have houses that, encroach into the buffer zone that are over 15 feet, right? I'm trying to figure out what the impact is it an aesthetic
So
impact? Is it a financial impact? Is it an environmental impact, Phil?
it's a codification of knowing how those impacts are going to change, whether it's Islington, the Maze, or somewhere else. That's right now, we are codifying something and going to town meeting to ask for a 2/3 vote. And to be able to say that we are fully apprised as to what those impacts are, I I go to town meeting with the expectation that I want to make sure that this is something that it is appropriate and it is necessary and it is something that I'm an advocate for. I don't feel that I necessarily can be the advocate is the point. So again, and it may be it's every member takes differing approaches. I take an approach of do no harm is what I said earlier, which is I don't necessarily want to do something because it may impact the vote next year. If we then say, oh, wow, we did something, we're not really sure, let's change it again. It's one thing if you're talking about Bess, where there's obviously an evolving set that's going to happen and going to be built upon as compared to making this kind of decision. So
Do you envision
obviously,
just a report, Phil, that shows what the neighborhood could look like 20 years from now and visualizing that? Like, I'm trying to figure out what are we going to be looking
I'm not trying to look 20 years from now, I'm looking
Okay.
2 to 5 years from now. I'm trying to look at, what are those applications do we know what applications are, current that the ZBA is going to reject? What is the process that is going on right now that this is, I mean, I know we have some information and it is differing than what I originally was thinking. And given that I now have an evolving or changing view as to how this is impacting, I don't necessarily say that I all of a sudden just switch gears and go an entirely different way.
Yeah.
So
Um,
I'm certainly not, I'm only one member of this board, though. Everybody else has differing views.
Yeah, I'm just curious, Ellen, is there something like you think would be beneficial for us, at some point this year that we could see some report that'll make us feel good either way on the decision we make in terms of, the judgment we're making here? Like, is there, the numbers are great. How many non-conforming, like nailing those things down would be great, but I figure we could do that in a week or two, right? Like, I mean, the town meeting's not till May. I think we can figure out how many non-conforming houses are in these neighborhoods in the next couple weeks.
I
Is-
would
No?
say we would not be able to
No.
do that
I
in the
was
next
just gonna
couple of
say,
weeks.
that's an enormous ask
Yeah.
on the
Okay.
staff.
It's
Everybody-
not,
yeah.
it's not computerized. It's not, there's
The,
not, it's not.
the lots themselves, finding the non-conforming lots would be something we could do, but the structures themselves, that would involve
Okay.
basically measuring every single house in their setbacks in town.
That's a lot.
This isn't
We
something
don't
AI.
have electronic surveys of every house in Westwood.
Okay.
Okay, that's helpful.
I mean, Mike, if you're asking my opinion, I'm going to be completely frank. I was on the fence about this from the get-go. I understand the ask, but I understand the inequity about the fact that, like I said, if someone lives next door to Ryan Chipman's house, who's 5 feet to the right, and so he's 10 foot in the setback, or he's at a 10 foot from the property line already, he can do what the Chipmans are trying to do far more easily than the Chipmans can do it. That bothers me.
Precisely.
I have a hard time with that.
Yeah,
So
Ellen, you're saying it far better than I could.
that's why I really like those pictures. Like, that troubles me. I have a hard time with that. That doesn't feel right to me. So this whole situation has been troubling for me from the minute we started discussing it, because I feel like there's a baked in problem here that there's not an easy solve for. I understand what the neighborhood's asking, and I'm more inclined to do something that offers relief, but I'm also sensitive to how is that going to affect if it's applied across the boards. And I understand it, then some of the other neighborhoods, it's 15 feet instead of 20, but how is that going to affect the rest of Westwood? And that's why I was asking, like, can we apply this to certain neighborhoods or zoning districts instead of across the boards? Because that, I don't believe a one size fits all solution is fitting here, but I'm also hearing that there are several people, residents that are asking for us to do something now. So it's kind of untenable in some ways from my perspective, but I don't know that I need a study of non-conforming houses and whatnot. I really want to understand, is there a way for us to offer relief to the neighborhoods that are most affected now without causing an effect in another neighborhood that is not desirable? And I see Mike Perkins has his hand up, so maybe he has an answer to that question.
No, that is not that is not my role here. I'm not providing those
Yeah.
types of answers. I'm sorry, Ellen. I am
Okay.
not I'm not a member of this board. What I was going to say is some years ago, the bylaw did allow for modifications to existing non-conforming structures via special permit, even if you weren't modifying the existing non-conformity. So if you were, so for instance, and I don't want to, just because it's on everybody's mind right here, 81 Cobley is a non-conforming house. It violates the left side, which is the west side setback of the property. The proposed modification, in addition to that house, does not modify that existing nonconformity. It expands to the right side on the east, again, going into that 10, 15-foot setback zone. Years ago, that would have been allowed by a special permit from the zoning board. There was no distinction between modifying the existing nonconformity of the nonconforming structure. It was, you have a nonconforming structure, go to the ZBA and ask if you can encroach into the front, rear, side setbacks, go over the height, whatever it may be. You had a nonconforming structure, great. You now have the ability to modify any part of that and create new nonconformities. That was changed. Nora would be able to tell you. 2022, it was changed so that modifying the nonconformity itself was a special permit. Creating a new nonconformity somewhere else was a variance.
Okay.
So there's again, like I said before, it's one of the quirks in the zoning bylaw that we back then somebody said, "Hey, I violate the right side setback. I'm going to go to the ZBA and violate the left side setback." And I don't want to say more often than not, but oftentimes those special permits were granted. And that's, I think, where you again heard the feedback from neighbors and residents saying, well, how come they can come over on this side of the property when they were already on that side of the property?
Right.
But Mike, did
Yes.
you work for the town before you were the building commissioner, or you at another town?
Yeah, I've been here for 13, going on 13 years,
Can you tell us
2014.
what were the impacts under the old interpretation? Can you worked in this space? What were the impacts?
Um, I don't, I need to parse my words. No, there were a lot of expansions and additions allowed that were, again, like I said, just because you violated the front setback didn't mean you could get 3 feet off the property line on the side. But you went to the ZBA and asked for a special permit, and if nobody came out and opposed you, you would probably get a special permit.
I'm sorry.
And
I
then you
think
could,
if I understand what Mike D is asking in relation to this particular, not that, but in relation to you can go 10 feet rather than 15 or 15 instead of 20. What were
Mhm.
the impacts of the way that your predecessor was interpreting this bylaw? Was there opposition from neighbors to specific projects? And stop me if I'm wrong, Mike Dudarian, but
No,
is
that's exactly it. You were in this, you worked in this thing, you worked in this area, you saw the impacts firsthand. What were those
Yep.
impacts on the old interpretation?
Um, Sometimes people complained, sometimes people didn't. Sometimes it was, how is this by right? I wasn't allowed to do this when I did my house. Okay, well, how come this person can do it? Other times it was, I love this guy next door to me. I don't care if he puts that over on this side and it's close to my house. That's my garage. I don't care if his garage gets closer to me. It's a very um it's a very amorphous thing. It's different from property to property, neighborhood to neighborhood. I mean, it's the same thing. We get calls and complaints all the time. How come I wasn't notified that my neighbor was putting a fence up? Um, you
Do
know,
you think you'll see less now under the new interpretation, or do you think you'll see
I think
similar?
I think it would, be different. I think we would get fewer um questions and or complaints or animosity from neighboring properties. I think we would probably get more questions, complaints, and animosity from prospective additions going on properties. So it depends. Who do you want to make mad? The person that's building or putting an addition on their house, or the neighbor? That's kind of it's one or the other. It's not that black and white, but that's a lot of the times what we see is, how come I wasn't told this person was putting this addition on their house?
Yeah.
And when the answer is because it's by right, they have no duty or notification requirement. Um, the next question we get from the next house might be, how come I can't do this? My neighbor was allowed to do that. So it just depends on again, and it's totally dependent on the property, the neighborhood, the neighbors. A lot of time, if you don't talk to your neighbor and all of a sudden you see an addition going on that's 10 feet off of the property line, you're going to say, what the heck is going on? Nobody told me about this. And we field those questions and we say, well, it was by right. You didn't have to be told. You didn't have to be asked. As opposed to, hey, I want to put up a 7-foot fence on my property line. You have to go to the ZBA for a special permit, ask permission, then your neighbor gets to weigh in whether or not you get a 7-foot fence on your property.
Thank you. I do see it looks like we have several comments in the Q&A. So, Tim, did you want to speak before we go
Yeah,
to the
just real quick. I think it's just important that we should be listening to the residents. That's the most important thing in my mind. So I really value the residents that have come forward, are actively participating in this lengthy discussion. And I just haven't, outside of Mike, I value your opinion, and outside of the perspective that you've been able to provide, no one has spoken in the community, at least to me, in opposition. Or so I guess I just, in my mind, the simplest thing is there was a 2-decade precedent set, and I'm not hearing other opposition. So in my mind, it just makes sense to codify or propose codifying what has been in place, and then put it, since that's who we're hearing from, and then put it to the people in town hall. Other than we can get really nuanced with different neighborhoods and whatnot. Phil, I understand your point. We could probably pick this to death because there's a lot of nuances to this debate, but I just feel pretty strongly that there's some loud voices here expressing concern in one direction, and I haven't heard any from residents in the other. And so that's why I would be in favor of putting that forward and then just taking it to town meeting and seeing if the people agree. Because I think it's most important right now to listen to the people.
Thank you, Tim. With that, talking about listening to the people, it looks, again, the segues tonight are writing themselves. It looks like we do have a few written Q&As, Amanda, if you don't mind.
Okay, so Nada, 32 Webster Street, she gave her address at the bottom. Still speaking to considering the voice of the building commissioner, you didn't listen to Mike's predecessor when you voted that the Washington Street building was a minor modification when it was clearly a major one. Do you want to respond individually, or do you want me to just keep going through?
No, that's fine. I'm fine.
Okay. Knocking down an entire building while holding a conditional approval from the planning board was a minor modification, and that was posed as a question. That was also from Nada. And we don't have your address, so if you can put it in the Q&A, we'll come back to it. Ryan Chipman, 81 Cobley. Mike D is correct in his understanding of the ZBA situation. The ZBA is clearly ruling in favor of the commissioner on the interpretation of the bylaw. They are not and cannot, for the creation of new nonconformities, make a special permit ruling to allow the kind of expansion we're proposing via an assessment of neighborhood impact. Ryan Chipman again, 81 Cobley. For Phil's question regarding current impact of the current interpretation, Mike Perkins stated at the January 20th meeting that 3 to 4 projects in the past 6 months alone proposed an addition that made use of the average height affordance and were rejected/forced to redesign as a result of the current more restrictive interpretation.
Ann's address is the same as Bobby's. It's 87
Okay.
Cobley. 87
Okay.
Cobley.
All right. Anne says, I am a neighbor in Islington and I am in favor of Chipman's average height rule that was followed by the former building commissioner. And that was not his address. And then Nada also added, thank you, Tim.
Thanks, Amanda, and thanks to everyone who provided public comments so far. Okay, it looks like the written Q&A number has gone to 0.
Ellen, I have maybe a proposal. We'll see if this works. Can we codify the building commissioner's interpretation, however, allow an exception, right, with ZBA approval, so they can look at all the facts of each situation, and if the ZBA approves, they can use the average height, right? Because again, in one situation where both of your neighbors have 25-foot roofs, it makes no sense to enforce this rule. It's not going to impact how that looks vis-a-vis the neighboring structures. I think the ZBA is in a position that it can take all these factors into consideration and make exceptions where these exceptions are needed. Because again, this just one size fits all doesn't sit well.
That's a good question. Is that within our purview to do? And if so, if that's something that we as a board could propose, is that something that's amenable to board members? And does that solve the problem?
I'd be interested in hearing Nora if that's even doable.
So much like your article on definitions, that's straight into sections 4.1 and 4.3, you could have an additional section in this article that proposes a new rule under the special permit process for non-conforming structures. So what you would say then in a case of a proposed structure that would not conform with notes 5 and 7, the applicant could appeal to the zoning board of appeals for a special permit.
And would that cover, just to make sure I'm understanding correctly, would that cover like the Chipman's project and some of these other ones we've been looking at? Would that cover those structures?
It would cover those structures that were only non-conforming with the notes 5 and 7. So it would allow a special permit process for deviation from the absolute 15-foot height rule within the setback area.
So and I'm just going to keep using the Chipmans as an example because that one was on our screen and it's pertinent. If they wanted to not have that chunk of the addition that would, the 5 feet into the setback chopped out, they could go to the ZBA for a special permit and say, can we please make it, uniform? If I'm understanding.
If you amend the section of the bylaw that determines when you go for a special permit and when you go for a variance, and you would specifically allow special permit applications to be filed in cases where a property does not meet notes 5 and 7, 5 or 7.
Is that consistent with the published
Yes.
notification?
Because we have that language that says, or take any other action in relation thereto. Let me just bring up the language of the article.
I would want to limit it to the average height under the old interpretation. I don't want, I think that would be right.
What was the old interpretation? I mean, we're putting words to paper. How do we, we need to.
Yeah, that's a good point.
We need to write it, not just say the old interpretation.
The average height, yeah.
What is that?
So
Median?
this is how the warrant article was advertised. So it's to see if the town will vote to approve certain amendments to the Westwood zoning bylaw, section 5.0 dimensional requirements and/or related amendments to section 2.0 definitions to clarify methods of measuring the height of a building and the height of a portion of a building located within a setback area pursuant to section 5.3 notes 5 and 7 as follows, or take any other action in relation thereto. So if your other action is to provide a special permit process when someone doesn't meet notes 5 and 7, then I think that is within the scope of this article.
I'm interested in providing relief to the people who need relief without opening up issues in other areas. So if that achieves providing relief to the people who need relief without necessarily having, because it sounds like there's still a discretionary layer in here, that it's just I don't want to say more open discretion. It affords people the ability to make their case to a board that will look at this and look at all the factors instead of being put in the position where they either have to uphold a decision or overrule it based purely on the words on the page rather than a bigger picture. So if that would provide the relief to the people who need the relief without causing issues in other areas, that seems like it might be a workable solution that doesn't require looking at every non-conforming lot in town before May. And that's just my thought right now.
I'm open to a solution because like I say, I want to stand up because there's a lot of people that that's why I think this is important, and perhaps I've been passionate at times, but I am open to seeing how the words read to see if it is doable, and certainly willing to consider any revisions and other interpretations to provide, a solution.
Thank you, Phil. And I understand the point you were making as well, that I agree with Tim. Listening to the people is really important, and we've heard loud and clear that there's a need for something. But I'm also really sensitive, having been doing this for a little while, that and seeing things that are happening in other towns where zoning was changed and then things happened that, the
Yep.
unintended consequences in the other direction, where now things are open to things that are detrimental to the neighborhood. So I do take your point seriously, and that's why I'm hoping we can find something that will solve the
And
immediate problem without doing some
And
other
then
things we don't want.
perhaps my passion is because I have also been involved in other situations with other towns. And I am telling you, codification is a big deal. It is an important deal. And when you go to town meeting and you're trying to say, put these words on the paper and approve it, if you lose, you've really made a major setback for the next year or the next 5 years or whatever.
But is
No,
the difference here is that it's been in place for a long time. There's a precedent. It's not new codification. It's essentially been there. It's just hasn't been.
Well, it was there for 20 years and then changed over the last, what, 3 or whatever. The implementation or execution, but there's been no codification. There's a differing interpretation with now, from the prior commissioner. And codification is different than just simply saying, how do we interpret what's existing?
Yeah, and I don't love the black and white rules, and so if this gives some discretion and allows parties to make a case where there's maybe an exception is warranted, I think that covers the relief part of
I'm
it.
incredibly sensitive to the need for relief.
Yeah.
I really, I mean, obviously their submissions and whatnot have an impact, but I also want to make sure we know what we're doing because I don't want to have unintended consequences.
well, what I like best about Nora's solution is it kind of brings this process, it would make it more comparable to the process for extending or, working with an existing nonconformity. Someone who hasn't, the guy who's 5 feet to the right still has to go to the ZBA. It's not by right. They still need to get a special permit. So I like Nora's proposal because it would provide the equity that I think is missing. Each neighbor, whether it's the people who are right at the 15 feet and want to go 5 feet over, or the people who are already at 10 feet and want to go up, they would follow a similar path. And I think that feels better. It would provide the
There's a
relief.
great deal more equity in that kind of
Right.
approach.
They have an equal chance to be able to have the same result, rather than one person has a great chance of getting without having to chop a piece out of their addition, whereas the other person would have virtually no chance of getting that outcome. So I like that. I see a lot of um, Maria's been waiting, then Mike Perkins, then Amanda. Can you? Oh,
You
looks
know
like
what?
Maureen
I
might
didn't
be having
realize.
that.
Well, you know what? Been on a while, so I'm down to 8%. Can you hear me?
Oh no. Yeah, we can hear you. You still with us?
Yeah, I am. Sorry if you lose me. I think Mike's idea is a good idea. I think that kind of does like solve somewhat for what they're asking for, and it gives them an opportunity to maybe do something that maybe they weren't going to be permitted to under the existing height. So if that is something that we think can be done, Nora said it was. Did you lose me?
Nope, you're still with us.
Okay, if Nora says it can be done, I think that is something reasonable. And if we need to look at things a little further, but this might be a fix at the moment.
Thank you. Mike Perkins, then Amanda.
So I just have, I think, so three things. One, the easiest way to address this, I think, again, as has been said tonight all along, clarification, codification of a hard and fast rule, I think, is the best way to go. Not to push back on you, Mike. Gray area and interpretation is the bane of the enforcement world. And I don't know if this would happen or not. I just know that in our experience, my experience, when people come to us and we say, well, now you have to add 6 weeks hold upon, and you have to spend, $600 to go to them and place an ad in the paper and things like that. We get that pushback a lot. Why can't I just do this? Why don't you change the rules, et cetera, et cetera? So the hard and fast rule is the easiest thing to enforce. I know it's difficult to, again, like Phil was saying, put words on paper and make sure they're the right rules and things like that. I would also say that if the board wants to, if there's an appetite to just say, you know what, it was there for 20 years, let's codify that into the bylaw and make no ambiguities in these 2 footnotes and say the average height shall be applied to these as well. I would also say, again, you run into the issue of, yeah, that one, my interpretation has been here for whatever, 2+ years. Joe's was here for 20+ years. The previous interpretation was there for 40+ years. I get hit by a bus tomorrow morning. Who knows what the next guy is going to interpret it as? So you want to have something hard and fast on paper, because when you start playing with how people are looking at things in different ways, it starts becoming, okay, well, the guy before the guy before the guy looked at it this way and he was here the longest. So do we put his interpretation in to the bylaw? One way or the other, I think it's just best to have something hard and fast on paper.
So you're advocating against a special permit via ZBA path?
I'm not advocating against that. I'm just saying that we oftentimes hear, I wasn't planning on that. We thought it was going to take us, 3 weeks or a month to get a building permit. We missed the filing deadline for the ZBA. Now we're going to be 3 months out. Now we're into winter. Now we can't start our project till the spring. We didn't know this was going to be the case.
Do you hear that from the folks who have an existing nonconformity that they're trying to extend?
We hear that anytime somebody has to go to the ZBA.
Okay.
No matter what it is. I mean, it used to be for accessory apartments. It can be for expansion of an existing nonconformity. It can be for the construction of a 4-car garage.
Okay.
All those kind of things, people will say, you know what, I was planning on moving into this thing in April. Now I can't even start the foundation until February. I'm not going to do that in the winter time, so I can't do it till next spring. So I'm just saying that there's unintended consequences all over the place. And again, I'm not advocating one way or the other. I'm just saying it makes our lives a lot easier, and it makes everybody else's life that's coming in for any type of permit or permission or application for something. If there's something written down and says, this is what you shall do, and this is how you shall do it. I always talk to contractors and builders, and I say, it's really easy to play the game when everybody knows the rules. If there's a gray area, it's really hard to play.
But I guess here there's a rule, right? You have the 15-foot rule. That's clear and unambiguous. Go do it as of right as quickly as you want, right? But if you want a little bit more, if you want to use the median or the average or however we can define it, right, and get a little more height based on that, then you got to go through the process. It's their choice.
Right. So I guess the question is, which 15-foot rule are we talking about? Is it the average height? Is it the hard?
Is there more than 2 definitions?
No, there's one definition for the height of a residential building. That's it. So if you look at a house that's 2.5 stories that has a 1-car attached garage, the garage might only be 18 feet tall. The building is taller than that. But that portion of the building is not 26 feet tall or 23 feet tall. That portion of the building that is the garage is only, 14, 16, 18 feet tall. We don't have a separate definition anywhere for the portion of a building's height. We only have a building height definition.
I'll just toss in 2 cents. I've been the unintended consequences that I'm saying. I've been heavily involved in drafting bylaws for another town, and there have been, which has much more complicated neighborhoods and whatnot. In terms of the impact of the draft of the bylaws that we've been working on, have had multiple inputs on unintended consequences as they impact other neighbors. I think we are we should be cautious about being less than careful about how we craft the bylaw. And that's where I just want to make sure. So I'm certainly open to, a solution, but I really dislike, I don't think we should be doing something by the seat of our pants to codify something where it does have other kinds of consequences in different parts of the town.
Yeah.
Phil, what do you think about this language?
Yeah, that's why I kind of like adding a discretionary layer. And Mike Perkins, I understand what you're saying, but like respectfully, like if it's part of the process, I understand that people don't want to go to that, but there's lots of things people have to go to the ZBA, or I'm sure there are developers on the planning board side that don't want to have to go through our process either. But I like to see a balance between oversight and I'm sensitive to what you're saying, but I guess that's not compelling enough for me to say I don't think it's worthwhile to explore a ZBA layer. Because again, that's what someone who's on the non-conforming structure side has to do. We have ZBA for a reason. I think this might be a workable solution, but I'm interested in what other board members have to say, but I also see Amanda's hand up. So we'll start with Amanda, and then I think we can look at this language.
All right, I don't want to prolong the conversation, but I want to say a few things. I hope it goes without saying that staff are not trying to sway the board one way or the other. For us, we just want clarity. So whatever you guys tell us, we will enforce. So I hope it's not perceived as us trying to push you in one direction or the other. In regards to going for a special permit, Mike does have a point. There are certain people, actually many people, and even construction companies where they hear the word special permit and they want nothing to do with it. There's also the additional costs that come with the hearing, not just for the advertisement, but also paying their contractors to be at those hearings and answer questions. That's significant cost. There's also privacy. Now you're talking about your addition with everybody tuning in. So some people care, some people don't. Again, not trying to sway you one way or the other. The other thing is it's still discretionary. So there is the potential consequence of they may not be mad at the building commissioner anymore, but then they're going to be mad at the ZBA. On the flip side, at least that discussion happened in a public setting. So just some other things to consider about going this route. Again, not pushing you one way or the other, but going back to intended and unintended consequences. I just wanted to point those out.
Thank you. No, I appreciate that. But again, I'm going to keep sticking on this process would be far more parallel to what exists for what I would call comparable situations in the same neighbors. You could literally have two houses next door to each other where one home, if we codify this as 15 feet, or even if we leave it as is, and whoever the building commissioner is interprets it as you're measuring from grade rather than, whatever, they have very little chance of getting the same relief that their neighbor gets simply because their house is situated slightly different on a lot. So that this to me at least brings some of that equity back and levels the playing field in a way that I think is more appropriate. That's just my opinion.
And you still can, as of right, do what you want to do to the 15-foot absolute requirement, which is what the rule is, right? It's you don't have to bring a special permit to do an addition. That's not what this provision says. So
Right.
I'm just curious, Phil, do you think this is there still I'm
Yeah.
curious what Phil thinks about like the potential of impacts that we don't see, because we are doing this very quickly. I want to
Well, so in terms of drafting, I would like to play with the words, but I think the concept is doable, meaning I think it is a creation of an option which provides a balance between relief, a opportunity for advocacy and further consideration. So I'm not gonna. I need to think about the wording because I don't actually. I think the wording I would change it in some respects, and I need to think about it more than just by the seat of my pants. But I think the concept is definitely doable.
And that I
That's
love
about as far as I'm gonna go. If you want a lawyer answer, I'll put on my clock and we'll do it by the billable hour.
Yeah, this is given that I had intended to call for a bio break an hour
Oh
ago.
my goodness, Ellen, what are you doing?
I think now, since we need to
He's my
take a
buddy.
minute to think about this, if people are amenable to a bio break, we can kind of take a moment, think about what we think about all this, because I appreciate this conversation. I understand it's been long, but I do think it's really important because we have kind of a Gordian knot to get through here. But I wouldn't mind a bio break. I'm sure there are other people that wouldn't mind. And then when we come back, we can continue discussing, exploring that option. And I'm going to put it out there, since we do have residents in attendance. By the way, we have 4 people in attendance at this time. I would be interested to hear from some of the folks who have weighed in on the need for relief if this proposed solution would be meeting the needs of the people who are asking for a solution. And I'm just going to put that out there. I know it's only 1 or 2 opinions, but I am interested in a temperature check. So I would entertain a motion to take a bio break at this time, to return within 3 to 4 minutes.
I
I
move
guess,
to
sorry.
adjourn for 4 minutes.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Maureen,
Aye.
Jill,
Aye.
Mike,
Aye.
Tim?
Aye.
I vote aye as well. I'll see you all back shortly. Remind me, I just need to call the meeting back to order, right?
Yes.
Let the record reflect the meeting is called back to order at 10:25 p.m. All right. So Nora had drafted some proposed language that would include a ZBA special permit process. So I think we should take a few minutes, or as many minutes as it takes, to discuss that option, and maybe hear from the public and see whether or not this is a potential solution we could take to town meeting, feel good about, and be advocates for.
Dora, can you zoom that a little bit? It's really tiny.
So I have 2 options here. One was adding the special permit option to the otherwise same article that adds the absolute height measurement definition. So let me just go back to the top of that article. So the article, as originally proposed, would add this language saying that the building, portion of a building within the setback should be measured for an actual dimension from grade to highest point of the portion of the building or structure within the setback area. And then the illustration that goes along with that is the 3rd illustration here. Then there's another section, section 5.4.2, which adds similar language describing how it's the actual height, actual dimension from grade to high point of the structure directly above that's measured for buildings within the setback according to notes 5 and 7. And then this is the additional language that would be to section 4.5.3.3, which is a section of our bylaw that determines whether you're going to be requesting a variance or a special permit for a new or expansion of nonconformity. So this would consider being within the setback area and higher than the absolute height of 15 feet. That would be considered a new nonconformity. However, it would be allowed to go to the ZBA for a special permit as opposed to a variance. But there would also, if you notice, there would be a limitation on it. The ZBA could not grant higher than a roof higher than 15 feet average height. And then the other option, if you're looking to go the route of just simply codifying the average height, then that option would be to amend the footnotes 5 and 7 to specifically say that they would measure average height. I think those are the 2 options before you. And then the 3rd option, of course, is not going forward with the article.
Okay. Thank you. All right, board members, thoughts?
I would say notwithstanding the above and cross-reference the section specifically, after the word above, notwithstanding section, whatever it is up above.
Just let me get to it. Sorry.
Yep, no, that's fine. Yeah, that's fine. I would say a proposed structure, I would take out in a case where delete the word oh no, wait a minute. Which
If
in the event that a proposed structure does not comply as compared to would violate, I would say does not comply with 15-foot. What's the impact of the word absolute?
Versus,
when we say actual dimension,
That's the word absolute is bothering me. If
Is
we
that
take out the word absolute and we simply say the dimensional requirements, or the actual,
how about height measurement described in,
yeah, okay, yeah,
we find out what those sections were.
yeah, just put a line or something for the moment. What was it?
Sorry, 542, 2.0 and 5.2. Okay.
Yep, okay. Described in right there, section, yep. For any portion of a residential structure within a setback pursuant to note 77, zoning boards of appeal shall have discretion as compared to shall have discretion to consider, shall have discretion to authorize,
allow?
Grant.
grant.
Although their discretion is to grant or deny.
To grant or deny, yeah, that's fine. Deny a special permit, section 10.3.
excuse me.
Thereby allowing as compared to allow after the 10.3. Thereby allowing. Take out the second allow. I'm open to other scriveners. I'm okay with that.
Do you have to add any clarification around the average height
The word,
language?
Yeah, is it the average height of the?
Yeah, how's it defined in the second option you laid out, Nora?
Average height.
I would just say the average height set forth above or something like
It's
set forth
within the
therein.
buffer zone. It's within the buffer zone, right? It's the average height
Yeah,
within the buffer zone.
But
Okay.
you're cross-referencing
Yeah.
I mean, I don't know that you have to cross-reference yet again, because I think that at the end, after the constructed with average height of 15 feet, comma, as set forth. And
Yeah.
I mean, I think we already have multiples, cross-referencing of sections, so I don't know that we need it again.
Yeah.
I'm okay with this. Not that I'm not a pain in the butt.
Phil, we
Where's
appreciate you
where's
being
the average height?
thorough.
Where is that definition? The
In the
average height
building, in the building permit, section 2.
section. Where does it say it?
Is it in the
The
diagram?
vertical distance from grade plane to the average height of the highest roof surface.
Right.
Building height, the vertical distance from grade plane.
That's, 2.0.
I am going to interject just as we're going through this. I see a comment from Ryan Shipman. I'm going to read it since I'm already in there. I want to thank the board for hearing the community. Small drafting I assume nitpick with respect to the text as proposed, but this is actually really good point. In the proposed edits to 4.5.3.3 to allow said structure to be constructed with an average height of 15 feet, he suggests it should read to allow said portion of the structure to be constructed with an average height of 15 feet, to be clear that the 15-foot limit doesn't apply to the entire structure.
So I would change him again and say to allow said structure, comma, or portions thereof, comma, to be constructed.
Well, I mean, that I actually am curious, if we just say said structure, does that imply the whole house? Or again, unintended consequences that,
But if we say said structure, comma, or portions thereof, it covers, it certainly would cover the Chipman concern.
Or portions thereof.
Mhm. Or portion. Can't say and portions, you have to say or portions
Or.
thereof.
Yeah.
Or portions thereof.
yeah, the portion within the setback. I think that achieves.
So I would go with Ryan's, but I would just amend it slightly. I'm okay with what he says.
Thank you.
That's good. Yeah.
You want to quote what you want typed?
So just copy and paste where it says should read.
I can't see his comments while I'm in share
Oh.
mode.
All right, hold on. Says the, what am I say? Said structure, comma, or portion thereof, comma, to be constructed with an average height of 15 feet. Okay, you can go back. You can close
Okay,
the
where am I
close
starting
the
from?
comment. You gotta, I can't see it because the question has to be closed or gotten rid of. There we go. So where let's see.
Thereby allowing.
Thereby allowing said structure, comma, or portions thereof, comma, to be constructed with an average height of 15 feet. Average. 15 feet. They just changed the E of that, put average should be A. Yep. Okay. I agree with Mr. Chipman with that change.
Thanks for putting the lawyer eye on it, Phil. Thank you.
I'm good. No,
Thank you, Phil.
see, you know what? I can be happy, especially when
Yay.
it gets late at night.
No, I mean,
I'm
you know
taking
more
over
about
Kate's role.
you understand the legal language. So, and you and my, all the attorneys in the room, I
I've been
appreciate.
involved in drafting bylaws, and it is a significant task because
Does grant or deny and then it's followed by thereby allowing? Does that read well? It might. It stuck out to me. 'Cause if you deny, you're not going to be thereby allowing. So
That's why I originally had said to consider, the discretion to consider a special permit, which would allow.
Consider would be consistent with the rest of the zoning bylaws. That's the word that's used most.
Is consider.
Okay.
Yeah.
There.
Oops.
Took
Right.
too much, Nora.
Yes, I did.
So just grant or deny. To consider. Yeah, that's fine.
Instead of thereby allowing, which would allow.
Well, considering wouldn't allow.
No, the special permit
He's
would
saying
allow.
the special-
Have discretion to
Oh,
consider
yeah,
a
yeah, yeah,
special
yeah.
permit.
It's the
pursuant
permit
to
that's
section
doing.
Permit would
Yeah,
allow
Yeah, you're
structure
right.
or
You're right.
Say which permit would allow.
Got it. Yep, no, that's good.
Yep. Yep.
I
Okay.
I think
Yep.
that covers what we're trying to achieve, and it sounds like that
Would address.
would address the concern in the community, and still it would offer the discretionary part of the process that previously had been kind of left to the building commissioner, and a previous different building commissioners had had different interpretations. This is a more formalized process that parallels, like I said, like what we already have for other types of similar requests. I feel good about that. Again, no disrespect to any building commissioners, past, present, future, but I like consistency and I like equity. And this for me solves that problem of the disparity between the opportunity for an existing, someone who's already not conforming with the setback and someone who is.
Then I think that's a great point to make at town meeting, Ellen.
Well, I'll be happy to do that. Since in theory, I'll be the first one to get up to defend whatever we're taking forward with backup from y'all, of course, if you choose. But yes, I think that that's really what it is for me. That's when we started talking about this, that was the first thing that jumped out at me as being problematic about the situation altogether, is that there was a baked in inequity that troubled me, that just it didn't seem right. So I like that this solves for that and gives everybody, in my opinion, more or less, an equal opportunity to have a path towards doing what they need to do to be able to expand their home in the way that works best for them and doesn't necessarily, doesn't unduly burden the neighbors. So
All right, I'm now going to give a collective pat on the back to this board and staff because we, in a transparent and a thoughtful way, have listened and have tried to react to the response to the concerns of the community. So I just want to say, well done to everyone, including myself. Thank you.
yeah. Yeah, thank you. Thank you to all my colleagues.
I'm straining my shoulder blade, patting
Yeah.
myself on the back.
No, I will, to use one of our favorite words here, I will echo that. I know this was a long conversation, but I expected it to be because
We all knew it would be.
it was an issue that I really was hoping we would find a path towards. Nora, thank you for a very creative solution.
Mhm. And patience.
And thank you especially to all the residents that, we asked several times for resident feedback and we got it. And I really appreciate that because that is what we need to be able to make informed decisions about how to proceed. And I really appreciated the input from everybody, staff. Mike Perkins took time to give us information too, and to the residents who provided feedback both through the petition and through some examples. That was really helpful for me. That is what I needed and wanted to hear to be able to figure out the best way to move forward in a way that addressed the concerns in an equitable way that didn't necessarily cause consequences for other neighborhoods or parts of town that were unintended. And I think having the discretionary layer of the zoning board process takes care of that, at least from my perspective. So I appreciate everybody on this. And it sounds like this will solve the problem for the residents who are being impacted negatively. I didn't hear anyone say it wouldn't from the neighborhood. So I'm hoping that this is a solution that would work for, I don't want to say all because nothing ever works for all, but that will work for the vast majority.
We outlasted them anyways. There's only 4 left.
But no, I believe that we would be hearing that is not a solution that would work if it was not a solution that would work. And
Well done.
yes, thank you, everybody.
Well
So
done,
Right.
everybody.
is this language that we as a board can support moving forward? I just have to ask that.
I'll
Yes.
say yes.
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 Sounds like I do see a hand up. And I would like to hear from Ryan Chipman again because I know this has been largely his effort on behalf of his the part of the community that he lives in. So I would like to hear from him again.
Thank you. And I'll be quick because I know it's late and I've kicked off a very intense discussion here. But just wanted to say, I think this provides a path forward where previously there was none, which I think is a reasonable compromise that does right by residents. And I know that it's I think the board's pat on the back is well deserved. I think the board has set a good example for listening to residents here. I want to particularly thank Tim, I think, for being the first and most consistent voice to speak up and say that we need to listen first and foremost, and that relief is needed. But thank you to all for coming to what appears to be a unanimous conclusion. So thanks. I'll let you guys get on with the meeting, but thank you.
Thank you. Thank you. And I do think this warrants further discussion as far as the setbacks and residential zones further down the road, but that is definitely beyond the scope of what we can do for this town meeting with what we've advertised. But I think it sounds like things in town may be changing and it is a broader community conversation about what is right moving forward for the future of Westwood in various and sundry zoning areas. So, but I'm happy to hear that this sounds like it provides relief for the immediate issue. Okay, I'm not seeing any other hands for public comment or anything else in the Q&A. So with that, I think we can move on to, where are we up to now? 6?
6, this is proposed changes to the Administrative Office Research District. So I'll just introduce the changes that are new from the last time we discussed this. The main changes that we'd already gone over before were adding screening and buffer requirements. And then board members were asked to submit proposed changes to the uses within the ARO district, and we received the highlighted proposed uses from one board member. The proposal would be to add animal hospital or animal clinic as an allowed use, to propose retail sales and services less than 10,000 square feet as an allowed use, retail services 10,000 square feet or more as an allowed use, and then we already had, I guess that wasn't a change, we already had commercial indoor recreation as a planning board special permit use.
Thank you. Board member comments, questions, input on these proposed changes? I'm going to state the obvious with a minor error of discovery. All of these things in theory would would be, commercial, taxable. I don't know. I mean, it's possible maybe a nonprofit animal hospital, but in general, all of these would potentially grow our commercial tax base.
So animal hospital, animal clinic, I'm not aware of any nonprofit ones, but it's always a possibility. For instance, you could have a veterinary school that's a nonprofit educational institution that could open one. Retail sales and service, regardless of size, would not be would be for profit. And commercial indoor recreation could be either for profit or nonprofit.
Okay.
So
Thank you.
I was the one who made these suggestions. I thought to try to give a little bit more opportunities. So
No, that's great. Thank you. Maureen.
I think the animal hospital or animal clinic would be probably something different and a good addition. I don't know about the retail sales and services. What exactly? I don't know what would go there. I'm not sure what you're considering. I know what retail sales and services are, but I don't know about those two. That's just my thought.
I was gonna say Phil wants to sell retail indoor
What are you
complex.
gonna?
Yeah, I've been doing all the talking tonight, but I was originally going to suggest only the smaller size as compared to both. For not like a completely mixed use, but to possibly attract something that we may also have office space or something else in other portions. But I guess the core of my reason for suggestion is to kind of like expand and kind of by expanding the possibilities, lock in a little bit better the commercial base that might be there. So that's kind of, it was just my thought process, and open to, I'm not tightly wedded because I looked over all the options and these were the only ones that I felt were possibilities.
Yeah, I guess the retail over 10,000 is the only thing I'm hesitating
Well,
on.
that was the one I was hesitating on. I was more comfortable with the smaller size as compared to also adding the over 10,000. So I'm open to others' suggestions or comments on that.
So I actually have a kind of a historical or legacy question for staff, probably Nora, because I think the ARO zoning was crafted a while ago. What was the reasoning behind excluding these particular uses when the zoning was crafted?
It was long before my time, so I could not say. Yeah,
Ooh.
it was
We need Steve
probably
Olenoff. Where's Steve?
25 years ago.
Nora, you're like the historian of the town. How can you not know these
This
things?
might be the first time I've asked you something where it
I mean,
was a little
she's
bit
been
ahead,
citing
but-
us to 1961. I'm like, come on, Nora.
I think it was before I even lived in Westwood, so I could go back and ask for the minutes for the town meeting at which they were adopted.
I was just
We
curious.
got you going, don't we?
If it was really just at the time, it made sense to distinguish that from some of our other commercial areas, or whether there was a compelling reason. I mean, obviously that was, if it was 25 years ago, Westwood is very different now. So it's not, I just was curious. It's not something that's a make or break for me. Tim, I saw your hand go up.
No, I was just going to ask. I was just looking over the map and I had a question, but I figured it out. So
Okay.
Do we have a sense what 10,000 square feet is? Is there a building you could point to that, like what's 10,000 square feet? I'm trying to picture
Is
that.
that like Roach Brothers, Nora?
Oh, Roach is quite a bit larger.
Oh,
How about what's on there right now? How
Smaller than the building that has from the Islington Pizza to the toast office. That's larger than 10,000 square feet.
Oh.
That's probably close to 15, I think.
okay, that's
Same with toast office to post office, that on High Street, if you can picture that.
mhm.
That's probably about probably pretty close to 15,000 square feet. So 10,000 square feet is smaller. If you're looking for an individual building that's 10,000 square feet, maybe something like the
The nope, never mind. That was 1900. I was thinking 9,000. Never mind.
the new salon is
I'd say a
So 2/3 of post office to toast office.
Well, isn't like,
Yeah,
isn't the
about
new,
that.
how big is the new CVS? Isn't it like 5,000?
that's it, 10,000. The new CVS is just under 10,000.
Oh,
Yeah, it's
it?
like
Okay.
9,000, right?
Oh,
I couldn't
yeah.
remember if it had gone down to
Okay.
5,000, and I was gonna say two of those, but no, it's just
Okay.
under.
It's just
10,000.
under 10,000.
Right.
Okay.
I was trying to
So-
think of something at University Station, but they're all
They're all-
much smaller or much larger.
So,
And I like the idea of freestanding to visualize. So if we were talking retail under 10,000, it's likely that it would be on a 12-acre parcel, it would be part of another project.
Yeah, there could be multiple retail establishments, none of which would exceed 10,000 square feet.
Right. And
Okay.
So you
So-
couldn't have a big box store.
Right,
Right.
as opposed to like Target
Well,
East.
that-
or
and
a
that's
Home Depot or a Walmart or.
Right, you couldn't do that, but you could have several, and you could have an Ann Taylor.
Okay.
I'm just wondering if that's just my opinion. is that really needed when there are like stores that keep turning over down at University?
Actually, University is 100% full and has been for a
Oh,
while.
'cause there's
We
one
need,
that-
we need
no,
more stores
It's
there.
actually pretty
Panera's
stable.
moved now.
I always
Panera's-
think of university as being very stable
It's
for,
very stable. It's too
Yeah.
stable in some regards. We have businesses looking to find a place to come into Westwood, and there are not vacant storefronts in Westwood.
So is somebody already taken Panera's spot?
Yes,
Yeah, the
Oh.
closure
before
was as
before
a
they
result.
left, there was another.
Yeah.
Oh, what are we
Their
getting?
lease was expiring, and they were shopping it to someone else. So there's another
Oh.
business already has its approvals to go in there.
Oh, that's good news.
Mhm.
The
Uh,
changeovers are usually the landlord wanting to change it, not so much the tenant.
Guess they want
That's
more.
So it sounds like the 10,000 square foot under might be a nice thing to incentivize.
I
I'm
guess
not sure about
the
like
question is
over.
10,000 and more.
Over.
That was the one that I had a little question mark.
Yeah,
as to
because
whether or
that
not
could
we
open, I
wanted
mean, there's no ceiling on that, right? It could be a 50,000 square foot BJ's, which I don't know that that's what we're looking to do there. But I do like the idea of incentivize, offering the opportunity, whether it was part of like, some retail and something else, or just, I like the idea of some more storefronts, particularly within walking distance to Islington Center. But I like the idea of that. I'm not sure about the plus because Nora, it's not like a range of 10,000 to 20,000, right? It's just anything over 10,000 is in its own
The
category.
way the bylaw is written now, it's just that, but you could create something if you want another category. You can make another category.
Like mid-size retail, somewhere between Ann Taylor and Best Buy. But
Mhm.
I don't know.
I don't know.
Yeah, I'm a little, I don't know. I'm not like for or against. I'm just, it's brand new for me, and I have to envision retail in those districts with the butters and stuff like that. Yeah, I'm just trying to figure it out. I'm curious what everyone else thinks, though.
I think the safer choice would be under 10,000, because I think it actually, in my own mind, it seemingly should work for that. And it's not the big box kind of concept, which I'm sure would cause a lot of heartburn.
But in Meditech, theoretically, a developer could purchase that, and is there 10 or 14 acres there? I mean, they could put, I don't know how many stores, 20 stores there. I'm just trying to figure out the worst case scenario, not the worst case scenario, but like the maximum use of the land, which would be very good for the town financially. But I'm just trying to figure out if that's the move we're making here tonight, is allowing that type of use.
Would it become like, and I don't
Like
know,
a mini legacy
like
place or something
legacy,
like that.
right? Yeah, or like, Derby
Sure.
Street. And that's, again, it would be very good for the town, but I'm not sure how. I mean, that's the question. Like, is that enough space where something like that could go in?
Derby, you're talking about the Hanover?
Yeah, Derby or like a legacy, they're very similar. I don't know what the acreage there is. I guess I would need to better understand what is possible if we were to make that change and just allow it.
Which
How
parcel were
big?
you looking at? Both of them, Phil?
Say that again, Maureen?
Which parcel were you looking at, the East Street one or the
Yeah,
Louder?
the Meditech
Both.
property.
Yeah.
Whatever you approve here would apply equally.
Both to both,
Yeah.
right?
Mhm.
Yeah.
That's an interesting question. And I don't know, would the folks at Fox Hill Village appreciate maybe some retail stores going in kind of on their campus, obviously not directly in, or not. I don't
Well,
know.
well, then definitely not the over 10,000.
Right.
That would
Yeah.
cause a great deal of heartburn.
Yeah,
But
that
I mean, in some respects, we're also trying to consider the commercial tax base. We're trying to, use the area in its most fruitful way.
Mhm. I know the Pine Hills in Plymouth isn't a one-to-one to Fox Hill Village, but they have a supermarket. They have some small stores on site, which for some of their residents, that's a nice benefit. So for Fox Hill Village, it might be nice to have some under 10,000 square foot retail that is close enough that they don't necessarily have to get in a car and go to. So that might be a benefit, but I agree with you. I think the over 10,000 square foot, given that whatever we do applies to both, might not work.
Right.
I was
Morning.
gonna say, could the retail be accessory to another use? Is that a way to? I'm just thinking out loud. Not that I'm not in favor of more commercial generally, but it just at
I
this
agree.
late hour, I'm loath to stick this in at the last meeting, and then I really am because I don't know what the reaction is going to be.
And I'm not crazy about to be honest, I'm not crazy about the retail in that area, at this point in time. But Nora, how big is that actual building that is on the East Street one? Do you know how many square feet that is? I just kind of want to get a,
Yep, it is 43,000 square feet.
so that
So
would
it'd be
take up like
25% of
half
it.
the
Building.
10,000 square foot,
It would be
correct?
under 10,000, so they would be smallish and only
4 or
cover.
5, at least 4 or 5.
But there's
Yeah.
7 acres of property on that parcel.
15
Right.
acres.
15 acres. Okay.
But it's probably not all usable, correct?
Well, there's buffer areas if this article passes that would come into play, but the vast majority of the land is usable.
Yeah.
Now, the portion that's got the gas line that's going through it, I know there's probably will be some restriction around that area.
I think that's just on the perimeter.
It kind of like, as you're coming up the East Street Rotary, you can see it going to the right of the property and goes right into the backyard of Elm Street.
Mhm.
So I'm wondering how far over. And I don't know what restrictions, you know how you couldn't even put a fence at the Washington Street one because of the gas easement?
You can put other things. So like if you don't build anything over it, it doesn't mean that you can't build on the other side of it. So like that could be a patch of grass or a median in a parking lot or something. Like there's ways to
No, I'm just
circumvent
wondering
that.
whether or not that would impede people that might want to build on it because maybe there's not enough.
Well, that's what I'm saying. They would only have to exclude that strip. They still could build on the other side of that easement. So it wouldn't limit the rest of the site. It would just limit that section.
Mhm.
Also to clarify that 4,300 or 43,000 square feet, that's over 2 floors.
Yeah.
So the
Was it
building
4,300
footprint
or
itself, 43,000.
43,000 square feet.
Okay.
Yeah, I mean, it's probably unlikely there would be a huge commercial structure there with the parking. And well, I don't know actually. We would need to consider it more. I'm just curious what the limits would be and then whether that would be the policy we're choosing, you know.
Yeah, I think if we include retail, I'm in favor of excluding the larger size at least. But the rest seems reasonable.
Yeah, I think I'm leaning towards that as well. Any other board member thoughts on this? Are we interested in at least incorporating like the animal hospital and maybe the small scale retail, or is there not consensus on that? I think we already reached consensus on the um recreational last time. But again, if we need to discuss that further, that's fine too. Um,
Yeah, I guess for the under 10,000, you could have not as big as Legacy Place, obviously, but you could have a shopping mall, not a shopping mall. What do you call it?
Strip mall?
Strip mall, exactly. So it's something similar, right? In that spanning the 15 acres with, and I don't know if I would, at this point in the last meeting, do that without getting feedback and allowing people to participate and stuff like that. I don't know what the reaction would be.
Yeah. I agree with you on that one. But the animal hospital sounds reasonable. I think that That would be something.
That's more of a time box kind of thing, unless of course it's like Angel 24-hour, but I don't think that's a high volume kind of thing, the way
Right.
that some other uses.
You want to use another, yeah, more
Right.
use for it.
We want to get a sense of the board just on yay or nay on the retail under 10.
Yeah, I think that's worthwhile. And then
Because I think we're probably all in agreement to exclude the over 10. I think we're probably mostly comfortable with the animal hospital.
Right.
It's a yay. I think we should just get a sense.
That's a good idea. And then I'll open it up to public comment. But before we do that, I think it's worthwhile to pull the board. So, Mike, what's your sense on the retail under 10,000?
I'm open to it, but not for this session.
Okay. Tim?
I'm okay with it.
Okay. Phil?
I'm okay with it.
Maureen?
I would have to look at that a little bit more. Right now, I don't know. I don't know, to be honest with you, right at this point in time.
Okay. And I'm kind of somewhere in between. I think the idea of it is potentially a really good idea, but I'm also like, given that the East Street in particular, and Fox Hill Village, the other side, I'm torn about bringing that forward now without a lot of discussion. But Nora, we're going to FinCom with this language, but if we get significant pushback, we still have the option to revise, yes?
Yeah, you have an option to revise, but I'd strongly recommend that you come to a consensus before you bring something to FinCom. It's one thing to revise in response to reaction you get from your public hearing and the FinCom public hearing that'll be held simultaneously. But if you go to FinCom not knowing what it is you want to do, that will come across and you won't be supported.
Yeah, that's a good point. Well, let's go back to the easier ones. Consensus on over 10,000 square feet. I think I don't need to pull everybody, but is there anyone who thinks we should move forward with that right now?
No,
No.
I take it away, even though I suggested it.
Okay. And animal hospital, is there anyone who's uncomfortable with that? Okay. I'd like to open it up to public comment before we decide on the retail under 10,000, because we are split on that one. And again, I'm of two minds. I'm sorry. I'm a Libra. I can't help it. So if there's anyone, we currently have 3 attendees, but if there's anyone who has any thoughts, public comment on adding under 10,000 square foot retail and commercial recreation to the ARO zones, please raise your hand or enter your comment in the Q&A.
I can go down East Street and knock on some doors if you want me to.
Thanks. Yeah. I'm not
Under 10,000 square feet is actually not that big. I mean, if you think of, 2/3 of the post office, 2/3 of the way to the toast office on High Street, that's like 3 or 4 shops.
Yeah,
But it's,
Maybe.
I'm
I
over
agree
the
that
side
it's
of town, two
it's per
CVS.
business, right?
What's that?
It's per, my understanding is it's per business. So you could, excluding the buffers, you have X amount of space. You could put 30 of those structures on there in a commercial strip mall, whatever you want to call it, right? It's not just, that's not the, you know what I'm saying? Am I understanding it wrong?
No, I believe any establishment would have to be no greater than 10,000 square feet. I don't think you could fit 30 of them there, but
Yeah, I was just
you
going to say that
you
would
could
be,
put more than one.
yeah.
I'm curious, what ballpark it for me? Is it 10? Is it 3? Is it 5? It's because that's the big difference to me. Having
I I
5.
could not say without,
Good
without a development plan to see what the parking is, what the access is,
Oh, yeah, you gotta have everything,
what the
yeah.
size is. Under 10,000 could mean 2,000 or it could mean 9,999. So, and
Different
depending on
percentage.
what size the retail is, or if it's not retail, if it's service, they have different parking requirements. So that's not something I could judge.
Yeah.
Nora,
we're
could you
trying to
share
keep
the
it as
use table one
commercial.
more time? Just, I wanted to see something quick. I'm sorry.
Yeah, just a minute.
Yeah, I'm definitely a big fan of trying to incentivize more appropriate commercial uses and not so many of the things that would pull that out of the commercial tax base, but I'm curious about a couple of things.
Excuse me.
Yeah. Sorry, I meant just the proposed changes. I should have
Oh,
been.
I'm sorry. I thought you were asking for the whole use table. Okay.
No, I'm sorry. I meant
All
the
right.
proposed
There you
changes.
go. I took out the over 10,000 square feet. That's what you're left with. The animal hospital, animal clinic, retail sales and services less than 10,000, and
You
commercial
haven't switched
recreation.
screens. We're
Yeah,
still
sorry.
seeing
It's
the,
still the full use table.
Oh, okay. Let me stop. Put it back up.
I'm sorry, I should have been more clear.
That's okay. Can you see that?
Yes. So, I mean, I guess it's currently an N. We're talking about going to a Y. Is there maybe a compromise? Maybe it's PB or ZBA or like, BA or is there, do people feel more comfortable maybe adding a discretionary level there, or does that not make sense at all? Should it really be just thumbs up or thumbs down?
I think
I'm
just,
interested in
I
anyone's
think just one separate. Excuse me.
I'm not opposed to adding a discretionary element.
I'm just thinking for the neighbors in both areas that, having, rather than it's just, sure, the use is allowed, having some level of oversight on that level might be appropriate, but
I'm okay with that, if that gets us to a consensus.
What are the bases that a special permit could be denied? Just very high level generally. Is it doesn't fit?
Detrimental to the neighborhood.
Okay, so it could be something just the structure proposed we don't think fits in with the character of the surrounding homes.
Or there's too much traffic or noxious fumes.
So we would have real discretion in it's not a formality that we'd need a really good reason why not to. We would actually have discretion to do something. I'd
yes.
be okay.
One thing I'll add is that if it ever is challenged, you'll want to have a consistent argument. So if it's traffic, for example, if someone can argue, well, you can have a series of businesses under 10,000 square feet that's going to produce the same traffic as a large store. That could be something someone could challenge, but that's only if someone challenges it.
I was thinking more like if someone wants to recreate Legacy Place there and we determine that's too large a scale for that neighborhood because of traffic and impacts and all kinds of things. Whereas if someone were to come in and, or if Meditech decided to, use half of their property to put a couple of smaller retail shop, it's more about scale from where I'm coming from. So that, whether it's one giant set of stores that are all connected or 30 smaller stores, it still might be, the volume might still be an issue. So that's why I was curious if it made sense to, and that's a good question, Mike, about what are the grounds for saying no.
Nora, if it meets the dimensional regulations, though, they can't deny it based on scale, right?
Yes, if it's a special permit use, then the scale is still has to do with the architecture and the layout.
Okay.
And yeah, it's still discretional.
Do we? Sorry, I know I'm trying to size this up. The across from the old BB's Cafe, there's that lot with the barber shop, nail salon, Westwood Pizza. Is that? I'm sorry to put you on the. Is that generally the size of what we're thinking, or would this accommodate a bigger commercial lot of stores potentially?
Let me see what the size of that is. I can tell you it's about half the size of Legacy Place. Someone had
About half.
mentioned Legacy Place. It's not,
Okay.
it's less than half the size of Legacy Place. The area where Dunkin' Donuts is on High Street, is that what you're asking about?
Yes.
It's 10,000 square feet of
Yeah,
building.
yeah, the land area there is 1.18 acres, excluding the Dunkin' Donuts. Dunkin' Donuts is another 0.09 acres. So, you know, one and a quarter acres
And so, and we're
compared to
talking,
15 acres.
but the Meditech parcel is, we think 15,
15
obviously
acres.
with the buffers, but okay. See, it's,
That's why I feel like adding some discretion around scale is like my mind went where you went, Ellen, on like just there's probably a way to do this that's nice and not overly burdensome to the community. So that's where I was thinking.
Yeah, that's kind of where I was going. Like, I think it's a good idea to offer the option, but maybe it isn't, sure. Maybe given that both of those abut or contain residential areas where there's established neighborhoods, adding that layer of oversight allows for the discretion to say, yes, this is good for the town and the neighborhoods, or no, it's not. Are folks amenable?
Another sense of the board, not to try to move this along, but I will.
no, okay. I'm okay as long as you feel like we do maintain real discretion and, you know, can reject projects just based on size and scale. I'd be okay with it.
I'm good.
Board of Appeals or Planning Board special permit?
Whether I'm good with that.
I go PB.
I'd go.
Yeah. I would go PB as well. It would be, to me, that would be kind of comparable to the way we do something like some of our other special permits like FMUD or whatever, and that, you know, that's PB purview. So I think that makes sense.
You okay, Tim? Yay?
Yeah. Yep.
Okay,
Works for
let's,
me.
All
all
right,
right, Madam
great.
Chair, let's move along.
I did take public comment on this.
We already did. There's
I'm
only
not-
two people. There's like
Yeah,
one person left.
exactly. If someone wants to add something, feel free and we'll loop back to it. Otherwise, let's move on to, PB 7 and 8, the general bylaw amendments and zoning relative to short-term rentals.
So we discussed this one a lot at the January 20th meeting. The only changes were to add a definition for and a use category for long-term rental to distinguish it from short-term rental. So we had short-term rental of 28 days or shorter, and I added long-term rental, which is more than 28 days.
Thank you.
Other than that, it remains the same as you saw on the 20th.
Sorry, I didn't mean to interrupt you. As part of the feedback we got from the resident where we talked about some of it, on alterations and whatnot, there was some questioning as to why we were undertaking this and whether or not it was necessary. And I guess my only comment on that is, you know, we were approached by a group of residents to explore this. So I think that's the answer to why we are looking at this. And it has come up before. It came up several years ago. So I think it's appropriate to discuss it. I mean, if there are folks who don't think it's correct, or that it's necessary, I guess that comes up at town meeting. But I think the answer to why are we discussing this is there's been ongoing interest within the community, both several years ago and then renewed interest now, because there are neighborhoods where people are being affected, not necessarily positively, by some of the short-term rentals in their neighborhoods, and we're asking for, you know, some level of oversight, like Board of Health, and some regulations so that they would have recourse aside from just going straight to the police department if there was an issue. So I just kind of wanted to address that. I appreciate when we get questions and feedback, and I like to be able to answer them if we can. Maureen.
I just have 3 questions. There's somewhere mention of putting a cap on it. Is that something we would even be interested in doing? The cap on the number in the town. And I think
Oh.
it was down,
I don't think there's
it was under
currently a cap in the
I think that
draft.
was under the select board, something down there. Da, 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 da,
Was it in relation to the fees, maybe?
No, I can actually, did I write it down? Oh, 315 dash 14. And that was just, do people think maybe there should be a cap or not bother?
Well, that's actually, I'm glad you asked that because another thing, there had been some talk, I guess I don't honestly 100% remember. I think I mentioned at FinCom that there had been some ask about whether or not we would ban them outright, and we did get feedback that that is not, we really shouldn't be looking at that because there have been challenges, other towns that have um banned
And
short-term rentals outright there have been lawsuits, and the municipalities apparently have not typically been victorious. And I think we did discuss at our last meeting that that's not actually what we're looking to do, regardless of whether or not there was some interest from some residents in banning it, that's not what this board's looking to do at this time. So I'm curious, would trying to cap it fall into that same category, or is that something?
So the way it's drafted right now, it allows the select board to issue regulations, and if they choose to put a cap in those regulations in the future, if this becomes more of a problem than it is now. So just to put this in perspective, we have fewer than 20 short-term rentals anywhere in town. That's less than 0.3% of rental of housing units in Westwood. So it's not a significant number. If it ever became a significant number, maybe at that point the select board might want to consider a cap. And if so, this would allow them to do that through regulation.
Okay, so we're not talking about imposing a cap now. We're baking
No.
in the provision for that if the
Yeah.
select board
Yeah.
were in the future to ever decide that was something they wanted to pursue.
Mm-hmm.
Okay. Is
We
that,
good?
does that work? Is that helpful, Maureen? Is that
Yeah, no, that's fine. That was just,
okay?
and
Okay.
then just one more thing. I know you're tired. We're all tired. 315-19.
I don't have a 19.
Where'd it go to?
Do you know what it was about?
It had fees or something with it.
There are fees. Let me see.
9? No.
9 could be
Submittal
315-9.
Yes, my eyes are gone.
Okay.
Well, my eyes are falling out of my head just looking at Nora's screen.
Nora,
There we go.
315-9, initial application fee.
Yes.
See how it says modification application fee of 100 and then in parentheses it says 50? Is it supposed to be?
Yes, we changed that, right? We changed it and didn't change the number in there.
Oh, so it's going to be 100?
Yes.
Okay.
So 250 for your initial one, and if somewhere in the course of a year you decide you have to change it for some reason, then you have to pay another $100.
And that was it.
We good?
I'm
Yes.
good.
All right.
Excellent.
Move
All
along.
right.
Public comment?
Well, I need to take public comment, Phil. Sorry.
No, we don't. Forget the public.
Well,
All right, take-
there's this thing called the law.
There's Nada still there. Okay, Nada.
Regardless of anyone responds, I still have to ask. At this
Of
time,
course.
to entertain public comment on short-term rental proposed bylaw. So please raise your hand or enter your comments in the Q&A. Give that a moment. All right, seeing none, Nora, feel free to move on to PB9.
All right, I don't think this requires any discussion. This is making indoor commercial recreation a planning board special permit instead of a ZBA special permit throughout the town, wherever it's allowed. It's currently allowed in local business, highway business, industrial office, and ARO.
Yeah, agreed. I think we discussed this pretty thoroughly. I will say, any board members have any questions, comments, or additional input?
No.
I think we're good.
We're good. All right. I will open it up to public comment. If anyone has any public comment on PB9, indoor commercial recreation, please feel free to raise your hand or type your comment in the Q&A. I am seeing none. So Nora, if you would like to move on to PB11 because we
Yes.
removed PB10.
So PB11 is housekeeping. They're mostly word changes and number changes. Nothing substantial. I don't know, everyone has them in their packet. I don't know if you want me to go through them. I think there are 15. Quite a few. Mostly number changes, some duplicative words. Vast majority of numbers that are wrong. Sorry, there are 14 errors.
Yeah, I think we've all seen them though.
Looks
Yeah,
good.
did everyone get a chance to go through them? If nobody had any questions.
Nope.
Nope, good.
Nope.
All
All
right.
good.
Good.
And then I'll open it up to public comment on housekeeping. If anyone has any questions, comments, or feedback on the housekeeping articles, please raise your hand or enter it in the Q&A. All right, I'm seeing none. I guess I need I would entertain a motion at this time.
Yes, so we need a motion to continue. You would be continuing to February 24th, where you'll be having your hearing at the same time and place as the FinCom's hearing on warrant articles.
Do we just want to do a verbal motion, Nor? We don't have.
No, I got it, sorry.
Oh, you do have
I'm
it?
trying to share.
Yeah, no, you're good. You're
Zoom's
good.
starting to get funky on me too. Maybe it's tired. I don't.
There we go. Can you see that?
I move that the planning board continue the public hearing for proposed zoning bylaw, zoning map, and/or general bylaw amendment articles for May 2026 annual town meeting to February 24, 2026 at 7 p.m. in the Westwood Public Library Community Meeting Room, or if necessary due to inclement weather, to February 24 at 7 p.m. via Zoom, where a Zoom link and associated call-in numbers will be provided on the town's calendar on the homepage at westwoodma.gov.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Phil,
Aye.
Mike,
Aye.
Tim,
Aye.
Maureen.
Aye.
I vote aye as well. That motion carries. I am going to make a suggestion that we continue the public hearing for consideration of amendments to various planning board rules and regs, etc., to a future date without discussion, unless anyone objects. And Nora, if that is a motion that we are allowed to make, if someone is willing to make it.
Yep, and I recommend you continue it till April 7th because I think we'll be very busy at your March 10th meeting.
Probably. I'll jump. I'll move that the planning board continue the public hearing for amendments to various planning board rules and regulations, standard guidelines, and meeting procedures to April 7, 2026 at 7 p.m. via Zoom, where a Zoom link and associated call-in numbers will be provided on the town's calendar on the homepage at westwoodma.gov.
Second.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Tim,
Aye.
Mike,
Aye.
Phil,
Aye.
Maureen.
Aye.
I vote aye as well. That motion carries. Okay, next agenda item was discussion of exploration of Chapter 40Y Starter Home Zoning District. I'm actually really interested in that, but Phil, if you don't object, could we continue this to a
Absolutely.
wonderful?
I have my heart wedded on it, but I want to have it when people actually are going to listen and are not tired. And we've had a lot.
Yeah, I want to give this the attention it deserves.
Oh,
So
I agree. I totally agree. Well, we're in wrap-up mode.
excellent. All right, so we don't need to make a motion on that. Sorry, I'm flipping through my pages. Minutes, thank you, because I'm behind a little bit here. Did everyone get a chance to look at the folks that were in attendance at the FinCom meeting? Were folks able to review the minutes for the January 13th meeting?
Yes.
Was there, so I move that the planning board approve the minutes for the meeting of January 13, 2026 as presented.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Maureen,
Aye.
Tim,
Abstain.
Mike,
Abstain.
Phil.
Aye.
I vote aye as well. That motion carries. Did everyone get a chance to look at the January 20th minutes?
Yeah.
All right, then I would entertain this motion.
I move that the planning board approve the minutes for the meeting of January 2026 as presented.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Mike,
Aye.
Phil,
Aye.
Tim,
Aye.
Maureen.
Aye.
I vote aye as well. That motion carries. Next agenda item is updates from agency and committee representatives. Has anyone attended any meetings they would like to report out on?
My only question, Amanda, we have the 9 a.m. Zoom on Friday. You said it's just gonna be a short presentation. I'm planning to just log in and attend, but I don't know if we're gonna call a meeting, not call a meeting. What are we doing?
So no one has told me that they will attend. I did notice it just in case.
Oh, okay, you did notice
But
it. All right.
there's I explained that the housing partnership was invited because you guys need to be able to answer questions on behalf of the plan you created. It shouldn't just be coming from me. So
Are we
the
gonna have a
options
quorum, do you
there.
think?
What?
Will we have a quorum?
I don't know. I think Matt was gonna try to make it, but I know he'll be kind of distracted by work. So he's the only one I've heard that of a
And
tentative.
nobody else? Okay, all right. Well, if we don't have a quorum, then we do what we do.
Mhm.
Okay, that was my only question.
Did anyone else have any meetings they'd attended?
I went to a Zoom WEAC meeting that lasted 1 minute, and it was about the repair cafe.
Oh, yes. And I think they have a
No.
meeting coming up, so you
Yeah,
might
they
have
do.
more to tell us next time. Long Range Financial got canceled. We didn't have a quorum, so it's been rescheduled, I think, to next week. So our next meeting, well, not at FinCom, but at some point I'll fill you in on whatever we discuss there.
This week.
It's this week. Sorry. Yes. What day is it? It's Tuesday. So yes, I'll report out on that after it happens. Did anyone else have anything they wanted to share?
There's a Canton Street Project Working Group meeting on Thursday as well.
That's right,
For
at the
anyone who's
Pine
interested
Hill.
in that.
At the Pine Hill in the cafeteria. And that is a good point. We will be getting an update on, I believe they completed the tree survey, so we should get a sense of the approximate number of trees and which trees would be affected if the project were to move forward. That is kind of pertinent to planning board if folks have a chance to attend or watch, because street trees are our purview under scenic road. So it would be good to get some eyes on that if you have time. Thanks, Nora, for the reminder. Any other agency committee representative reports at this time?
I attended a pet and bike meeting, but they're working on a bunch of stuff, but nothing to report right now.
All right, well, thanks. I'm happy to see all our liaisons are liaising. All right. Then our next agenda item is general miscellaneous updates and administrative items. Staff,
Nothing.
nothing? All right.
Thank you for signing the A&R plan.
Oh, yes, yes. All right. The last agenda item I have is upcoming board meetings. And what I have in my packet here is we have planning board meetings on March 10th, 2026, April 7th, 2026, April 21st, 2026. We have the FinCom public hearings, which we mentioned before, on February 24th and 25th if needed, 2026, March 24th and 2025th if needed, 2026. And then the annual town meeting is May 4th, 2026. Did I miss anything? Town elections, when is that? April 28th, 29th?
I don't know the date.
I don't remember the exact day. I'd have to look, but whatever that Tuesday in April is. So so everybody make sure you're registered to vote so you can come on out and vote. Aside from that, I think that's the end of our agenda unless anyone has anything else.
It's
Not seeing-
April 28th.
Thank you. Hey, Mike,
Yeah.
I was in I was right. That's a beautiful thing. I'm gonna mark this day on my calendar. with that, thank you to all of you. This was a long discussion, but I think we nailed down our language, which was really important. So I appreciate everyone's tenacity. Thank you to all the residents who attended and shared their feedback. As always, it's critical to our process. We need to hear from you. So thank you for everyone who took the time.
Move to adjourn.
Thank you.
I move to adjourn.
Second.
I have a motion and a second. Is there any further discussion on adjournment? Seeing none, roll call. Phil,
Aye.
Mike,
Aye.
Tim,
Aye.
Maureen,
Aye.
vote aye as well. Thank you all. Good night.
Have a good night,
Night.
everyone. Thank you.
Thank you, Nora.